joined by the Auditor General of South Africa, and also we have the representative from the South African Medical Association. I need to declare this venue as a GP legislature precinct. So I, Honorable Andiswa Mosai, the chairperson of the Finance Portfolio Committee, I hereby declare that the Southern Sun as the precinct of the Gauteng Provincial Legislature. This is in terms of Rule 56, subsection 2 of the Standing Rules of the Gauteng Legislature. Version 5, Revision 2, read together with Section 2, subsection 1, and Section 28 of the Powers, Privileges and Immunities of Parliament and Provincial Legislature Act number 4 of 2004. So for the duration of our meeting, this place will be the precinct of the Gauteng Provincial Legislature, as I said. Thus, the standing rules of the legislature will apply and govern all the engagements of the day. The precinct of Parliament Provincial Legislature as described is as follows. Is the area of land and every building or part of a building under Parliament's control, including the chambers in which the proceedings of the houses are conducted, and the galleries and lobbies of the chambers, every part of the buildings in which the chambers are situated, and every forecourt, yard, garden, enclosure or open space appertinent thereto. The committee rooms and other meeting places provided or used primarily for Parliament's purposes, and every other building or part of a building provided or used in connection with the proceedings of Parliament while so used. Let me confirm if members understand the contents of the rule. Member Hickley?
Sure, I do, Chair. Thank you.
Thank you so much. So as I mentioned, the purpose of today's meeting is really to receive a presentation on the FIS topic from the Health Professionals Council of South Africa, South African Law Reform Commission, the Auditor General of South Africa, and the South African Medical Association. We are going to start with the Health Profession Council of South Africa. I'm going to move then to the next item on the agenda, if the agenda could be flighted, if we're able to, which is apologies. I'll request the administrator to read out the apologies.
Good morning, Chair, honorable members and colleagues. Chair, we have 4 apologies from honorable members. One from Member Evans, who's unable to attend as she's attending an economic development meeting. Another one from Member Makwala, who's unable to attend due to party business. And another one from Member Ngobeni, who is away on legislative business. And Member Rubenson, who's unable to attend as she's attending SATCOPEC conference in Lesotho with Scopa. Thank you.
Thank you so much. So we have not received an apology from Member Tlebere because she's also at SATCOPEC in Lesotho?
No, we have not received any apology from her.
All right. Can I request that we note the apologies, Member Hickley? Member Hickling, can we note the apologies? Thank you so much. The next item on the agenda is the confirmation, and I'll ask Ntate Nsane to take us through.
Good morning, Chair, honorable members and colleagues. May I also extend a warm welcome to our valuable stakeholders. Chair, you will have taken us through some of the agenda items, and now we are on the confirmation of the agenda. The next item, Chair, is FIS activities. Maybe if I may just take members through the FIS topic. It reads thus: a root cause analysis of accruals and the impact thereof on service delivery, a critical analysis of accruals and emanating from medical legal claims. The next item, Chair, the first presentation, Chair, will get it from Health Professions Council of South Africa. The next one, it will be from SAMA, which is South African Medical Association, followed by South African Law Reform Commission. And then the final presentation will be from the Auditor General. Chair, maybe I just need to indicate, in terms of our planning, we had planned that after the second presentation, if time permits, we can go on lunch, and then after lunch, Chair may determine as to whether we have a 30 minutes lunch or 1 hour lunch, and after lunch we'll have the South African Law Reform Commission as well as the Auditor General. The fourth item, Chair, is followed by the provincial bills, and then NCOP bills, resolutions tracking, petitions, correspondence, and date of the next meeting and adjournment. Thank you, Chair.
Thank you very much, Ntate Ntsani. Member Hicklin?
Thank you, Chair. Am I correct in assuming that was why I was focused on my computer? We have not received the presentation from the AG, am I correct?
You are correct, Member, not yet. However, the AG has given us an undertaking that they are coming, and then they were just penal beating their presentation. We should receive it anytime soon.
Thank you so much.
Thank you, Member Hicklin. Can we note the agenda?
Noted, Chair.
Thank you so much. We'll request when Member Klava joins so that we have a mover second at that time. Thank you so much. So the next item is on the referred reports, first quarter performance reports 2025-2026 financial year end, which is where the presentations are. So I think that Ntsani is trying to correct me.
FIS.
Is it, okay, so it's FIS, not, no, okay, FIS activities, because we need to record it properly. Ntate Ntsani has taken us through why we are here, members, but just before we can hand over to the Health Professions Council of South Africa, just to note that as a committee, we realize the scale, of the problem of medical legal claims and the accruals that Gauteng provincial departments are dealing with. And it goes up to tens of billions of rands. And when we started in this administration, 7th administration, we were informed that there were around 18 billion, and we are told now between 2024-25 they've been reduced to under 7 billion. But yet we know that the methodology is under scrutiny because we realized there were discrepancies in the last, when we received the last quarter, and there's rising claims, and they do threaten the provincial and national health budgets, so the fiscus. They are clinical failures that we have observed. Also poor record keeping, weak legal defense, fraudulent claims, and systemic governance gaps that we realize are there. Hence, we want experts to take us through that. And we realize that the impact of the medical legal claims is really on the strains. They cause strains in the budget, defensive medicine, and they do reduce morale and retention amongst health care workers, and there's also governance risk. So hence we have requested that the stakeholders must just take us through. So I'm going to hand over to the representative of the HPCSA to just table the presentation, and we will deliberate on the matter after that. Thank you so much. You will introduce yourself, Mayor Padayaki. Thank you.
Thank you, Chair. Good morning to you, Honorable Chair and Honorable members, as well as my colleagues from the different areas of collaboration as well. Firstly, I would like to record apologies for the Registrar, Dr. M. Maseka. He unfortunately has to attend a council meeting today, and the council is at the end of its current term, so it's one of the special meetings that he had to attend. Chair, I think at the beginning, I just want to set out that my presentation is slightly different from the topics that were presented to us. in terms of our role as the HPCSA, in terms of, how we fall into the overall value chain, in terms, and I'm quoting Mr. Nsane in this regard, in terms of how the HPCSA gets involved, not from a policy perspective, but I'm looking at it from the perspective of the professional conduct inquiry sphere. So in terms of the presentation, I have just included a presentation, and I'll be very brief. The presentation is quite detailed in terms of our professional conduct processes, and then I'll touch generally on some of the topics that you as a committee are more focused on. So with your permission, Chair, that is the presentation overview. Firstly, it sets out the legislative mandate of the HPCSA, and then as indicated, I'll just look at the disciplinary powers of the professional boards. The professional conduct processes are a direct power which the boards exercise in terms of their own norms and standards which they regulate on. And then I'll touch a little bit on continuing professional development from two perspectives. One from the perspective of once professional conduct matters are finalized, some of the penalties also include, depending on the nature of the offense, also include the practitioner who was found guilty to undergo additional training in terms of certain areas that may have been found to be lacking. And this contributes towards the CPD points that they would need to collect eventually, as well as there are also penalties that involve further training in ethics issues if that is found to be lacking. Chair, and then the last part of the presentation, I'll just look at, whilst you look at, your topic is slightly different, but I'm just looking at the role of the HPCSA and the collaborative efforts that we take an important participatory role towards protecting the public in terms of our overall mandate, which is to guide the profession and to protect the public. So, Chair, just on the aspect of the legislative mandate, I set out that the HPCSA is established by an Act of Parliament, and that's Act 56 of 1974. There have been various amendments to the legislation, but by and large, it is the founding legislation, and it is to be read with the subordinate pieces of legislation, namely the regulations and some of the rules. The various professional boards issue rules from time to time, as well as regulations pertaining either to scope of practice, to regulations that are relevant for that particular board in terms of also training criteria, etc. So the Act establishes the Council and the 12 professional boards, and as a regulator, the Council it has an onerous duty in that it has to provide for control over the education, training, and registration for and the practicing of healthcare professions registered under the Act, and then to also provide for matters incidental thereto. So I've also set out the main frame, and I'm not saying that the other objects are not important, but the more important, or I've picked out some of the objects and functions of Council, which is set out in Section 3, that possibly talks to your focus today in terms of your focused intervention study. And some of it includes the Council is responsible to coordinate the activities of the professional boards established, and that I made reference to the 12 professional boards. It's also the Council's function is to serve and protect the public in matters involving the rendering of health services by persons registered or practicing a health profession, to be transparent and accountable to the public in achieving its objective and when performing its functions and exercising its powers. Chair, one of the important objects of Council is also to uphold and and maintain professional and ethical standards within the health professions, to ensure the investigation of complaints concerning persons registered in terms of this Act, and to ensure that appropriate disciplinary action is taken against such persons in accordance with the Act in order to protect the interest of the public. So I think in terms of the value chain, Chair, this is one of the areas that that is seen to be talking directly to the topic under discussion, because inevitably when practitioners do or there are complaints lodged against practitioners where they fail to maintain their professional standards, etc., those complaints are then referred to the Health Professions Council, and the unit that I come from, the Legal and Regulatory Affairs Department, is responsible for the investigation and for the prosecution of those complaints. So just to continue on the next slide, with respect to the disciplinary powers of the professional boards, and one of the powers that the boards have is the power to conduct disciplinary proceedings against registered practitioners. And again, as a constitutional democracy, we ensure that this is a fair and reasonable process in terms of the various other legislation that influence proceedings, and in terms of Section 41 and 42 of the Act, these provisions set out in detail the disciplinary powers of the board. Aligned to this section, there are regulations that have been issued. So the regulation that we deal with on a daily basis is the regulation that relates to the conduct of inquiries into alleged unprofessional conduct, and these regulations set out the detailed processes right from investigation of the complaint up to the stage of prosecution of an inquiry. But for an inquiry to take place, the preliminary processes must establish that there's a prima facie case for the practitioner to answer to. So, Honorable Chair, at this point, I think I want to emphasize that our proceedings are quasi-judicial in nature and subject to review and appeal processes, both in the High Court and subject to appeal processes internally as well. In terms of risk, the Council has also issued suspension regulations, and I'll touch a little bit more in detail as the presentation unfolds. In instances where a practitioner may pose a serious threat or poses a risk of harm either to himself or to the public at large, in those instances there's a slight deviation in terms of the overall procedure, and the practitioner can then be brought before a suspension hearing, which will consider the allegations. There's also investigations that are conducted, and depending on the nature of the offense, it's usually an urgent type of proceeding, and the practitioner can then be put on suspension pending the holding of a formal inquiry. So I've just indicated on the next slide the Government Gazette, and that is the Gazette of 2009. It's been amended a few times. There's an amendment that was done in 2020, and there's an amendment that was done in 2023. The 2023 amendment, there are certain provisions that are currently being challenged in terms of a review application, and those pertain to issues like it regulated the holding of virtual inquiries and reduced the time frame in terms of which practitioners could respond, because what we found is that in the past regulations they were given up to 60 days to respond, and that's 60 working days, and so the whole process becomes delayed. One process delayed leads to a delay in the next stage of proceedings, and what ultimately happened is that we inevitably face a backlog, and that becomes an issue in terms of our reporting to Council, because this is one of the key indicators in terms of which performance is measured at a Council level on the macro level. So in terms of the disciplinary processes, as I've indicated, it is strictly governed by the regulations. Regulation 2 provides for the lodging of complaints. We also have Regulation 3, which provides for mediation. And I must emphasize to the committee that this process is actually taking off quite well, in that we're seeing a lot of successes in the mediation process. It's an independent process currently, led by a chief mediator, and she's got a team of mediators who assist her. So minor complaints are referred to mediation, and of course it's a voluntary process. But as I've indicated, in terms of the cases referred, we are seeing quite enormous success in this area. Regulation 4 provides for the process of preliminary inquiry, and I'll be quick through this, Chair, in terms of the investigation, the call for more information. Generally, the complaint is reduced in affidavit format, and then the practitioner is given an opportunity to respond. This serves before a committee of preliminary inquiry for deliberation, and this committee also has wide-reaching powers. It's essentially a peer review committee, but it has some limited powers in terms of issuing fines for minor transgressions, or it can also issue a penalty of a caution and a reprimand where it is of a minor, if the transgression is of a minor nature. But again, the severity or otherwise is based on information placed before it, in terms of not only the complaint but also responses from the practitioner. So it also has the power to note the explanation for minor offences, or where it is noted, the complainant has the power, not power, but the complainant can take the matter forward in terms of an internal appeal. Where the matter is referred to a professional conduct inquiry, this is regulated in terms of Regulation 5, and this is now where the formal process starts. It follows almost a civil process in that there's a pre-trial conference, there's exchange of documents taking place, but before that there's a charge sheet that's issued out to the practitioner, and Regulation 9 sets out in detail the process in terms of which the hearing takes place. It's chaired by a panel who, the chair of that panel is a legally qualified person. There's a community rep on the panel as well as one member of the board, in terms of which the practitioner is registered in, as well as 2 members of the profession, and these 2 members are normally sourced from the outside. So the practitioner also has the right to be represented, and in most instances with the bigger boards like the medical and dental board, they are generally represented by attorneys through their professional indemnity insurers. As I've indicated, Chair, there are internal processes that, appeal processes that can be followed by either the pro forma complainant, who is appointed by counsel, and the pro forma complainants are legal advisors who are employed by counsel specifically for this task, or the respondent can also, after an inquiry, challenge the process through an internal appeal, and I've just set out some of the other general provisions. Coming back to the next slide, the suspension processes, I've just indicated, Chair, in terms of where there's identification of a substantial risk of physical or mental abuse or harm generally to either the practitioner or the complainant, then we invoke the suspension proceedings. And as I've indicated, it also follows a process. There's a chairperson of a committee appointed by the chairperson of the relevant board, and 2 members of the profession who sit in deliberation, and the practitioner has the right to be legally represented. And following this, it is either referred to a formal inquiry, and the practitioner also has the right to appeal to the High Court if he's dissatisfied with processes. Now, the next slide, Chair, I've tried to tune this into the presentation that you were expecting today, or your topic for discussion, rather, Chair. In terms of just overall, the burden of proof in the professional conduct matters, the pro forma complainant who is legally qualified must prove on a balance of probability the charge against the respondent. And this is similar to the burden that needs to be exchanged or proven in a civil trial. And we do have instances where, in instances of clinical negligence, for example, on, under the category negligence, where complainants do lodge complaints at the council following the formal complaint process, but parallel to that also institute civil action on the outside. So it does not impact per se on our processes, because our processes are independent of the civil proceedings, but we do get instances where complainants will try to use our processes if they are successful, for example, or if there's a possibility of a settlement on the outside, then they may want to withdraw, but the council retains, or the professional board retains, the right to proceed even if a complainant decides to withdraw the matter, depending on the nature of the offense. And our processes, as I've indicated, quasi-judicial in nature. It includes, it involves the calling of witnesses by both parties, including expert witnesses. And the pro forma complainant proves on a balance of probabilities either a breach of the accepted norms and standards or the ethical standards against the scope of practice for that registered practitioner. And we also get instances where criminal proceedings may ensue, and I think, and I can mention the name of this particular practitioner because it's been in the public domain, the matter of Dr. Shevel, the headache clinic practitioner, where the courts also refer matters to the HPCSA for investigation, where it appears during their proceedings that there may be some transgressions of ethical practices. In this instance, there's also a referral previously done, but also in terms of what transpired during the leading of evidence. Partially, there were some other transgressions that were identified and referred to. There's another matter that also comes to I mean, if my memory serves me correct, Chair, the matter of Dr. Beale, the pediatrician. So, again, I just put this in to just demonstrate that in view of our proceedings being quasi-judicial, it's also a very legalistic process. We're also faced with challenges in terms of very aggressive defenses, especially where, you know, a practitioner, well, there are allegations, but where it is almost certain that a finding is imminent. We're also faced with interim challenges to the High Court. We also have a lot of litigation in terms of either stopping proceedings or reviewing certain interim decisions, like where points in limine are raised, technical issues are raised before the proceedings commence. So we do get quite a lot of that as well. And then there are also attempts, you know, to interdict the proceedings going forward. So it is very legalistic in nature, and we face the same challenges that you know, parties face in terms of the general litigation processes on the outside. I've dealt, the next slide, I've dealt with the appeal processes as well as the processes that allow for internal appeal as well as review. I've just included a slide that looks at medical malpractice and the definition of medical malpractice and how it relates to complaints that may be referred to us in terms of the deviation of that is required in terms of, you know, a practitioner's failure to conform to the required standard of care. lack of skill or negligence in providing care. So that standard of care or lack of skill will talk directly to our ethical practices, our norms and standards that is determined by each professional board for the practice of that particular profession. And where healthcare professional deviates from the accepted norms and standards, and where it may result in injury or death to a patient. So that's where we are involved in terms of the complaint process. So, Chair, I also want to just share very, very raw data. This hasn't been analyzed, but I've just extracted data in terms of for the 5-year period, and I've done this because we are in the process of finalizing reports in terms of the handover reports that we need to provide to the next council. Across our 12 professional boards, this is the total number of complaints that we received in terms of medical I would say negligence, very broadly categorized. It doesn't only relate to clinical negligence, but it also relates to other categories that we use currently. We don't have a category that speaks specifically to negligence issues. So there was a total of 1,618 complaints that were received. But I also want to caution in terms of just taking this data as it is, because I said it's very raw data. We've just done a calculation of the number of complaints received that we term broadly under negligence. And this is just complaints. It does not talk to our finalized process of matters that have served before a professional conduct inquiry, and where outcomes have, where the outcome would be that a practitioner is guilty of a particular offense that we can categorize under negligence. And I must indicate that out of these numbers, a total of 88 matters were finalized at inquiry level. But again, I just caution against just using these numbers, because in the 5-year period, I referred to backlogs, I've referred to investigations that may take longer. So they don't necessarily correlate to the 1,618 complaints that I have indicated that we have received overall. Chair, then finally, in terms of, I think I missed a slide, continuing professional development. This is one of the pointed questions that were referred to us. We do have the CPD program, and it is in terms of Section 28 of the board, of the Act. It's the responsibility of every practitioner to undergo additional training, and it is one of the mechanisms that the Council has at tracking skills, knowledge, and experiences that are gained both formally and informally past the initial training period. It is compulsory. There have been various reviews to the CPD training requirements, if the additional requirements in terms of obtaining CPD points. It's a process that's long in the offing, and the Council has sought various interventions at making sure that it works, because there's also the very real problem that we may have where we have large numbers of practitioners not complying. So in terms of processes, it is not feasible to actually suspend large numbers of practitioners for non-compliance if we look at our role in the overall healthcare system. But I must indicate that the rules have been amended. There's a rule that was published in 2024. It's effective, and going forward, the CPD requirements have really been sort of put into context, taking into consideration all the realities and the practicalities that practitioners face. And it is now enforced over a 12-month period. So for a particular year, there are requirements for each professional board, and the rules set out, and I can share that with Mr. Nsane if members would so like to see the determinations in terms of each board, in terms of the requirements, but the requirements span across the board, and Chair, I think this was part of one of the questions that you wanted to look at. It includes clinical practice, includes ethics, it includes human rights, and it includes health law topics that practitioners are required to obtain CPD points in. So again, I did refer to at professional conduct inquiry level, some of the penalties that we impose as well also involve the obtaining of additional CPD points, which are tracked by we've got a dedicated unit. It's the Professional Practice Division, and CPD forms one of the 5 functional areas for this particular directorate. So in terms of ensuring that practitioners are kept abreast in terms of new innovations, in terms of enhancing training, etc. Yes, this is the mandate of the HPCSA, and it is being done quite vigorously. Going forward, there is an indication in terms of the raised compliance rates that we are coming to the point where non-compliance can now be effectively enforced, in that should practitioners fail to comply, then the issue of suspensions do loom. And Chair, I also want to issue a disclaimer. I know that it's very topical at the moment, but I want to assure the committee that it's one of the areas, focused areas, that the registrar is also paying very careful attention to, and that there is a really marked improvement in terms of enforcing the CPD compliance. So with that, Chair, I would like to, I think I've just missed out, sorry Chair, just one more slide. In terms of our collaborative efforts, in terms of your question around policy development and areas into improvement of patient safety, we do collaborate with other regulators within the health sector. We have MOAs with the Council for Medical Schemes, South African SAPRA, and the Pharmacy Council. We also engage with professional associations and with other bodies. We also belong to the forum established by SIU in terms of the health forum, where specific matters are dealt with. We also collaborate extensively with indemnity insurance, who provide insurance or indemnity, professional indemnity cover for registered practitioners. We do keep abreast in terms of their thinking, in terms of the cover that they provide, etc. And we do give input in terms of what we see as some of our outcomes. In terms of systems improvements, Chair, we're also we're currently improving our IT systems, where we can now we're looking at extracting data that will give us certain indications in terms of trends, analysis, etc. So that is all in the pipeline, and it's all being something that the HPCSA is working very vigorously towards. And I must also conclude by saying that the registrar, with his new philosophy, he's come up with the Ngoko philosophy, which means now he's instilled this as the founding philosophy for how the HPCSA moves forward. We've been in the limelight quite a lot, but I can assure you that under his leadership that things are starting to see a turnaround. In terms of reporting at departmental level, Chair, we do compile our 5-year strategic plan. We do record and we report performance to the department, and we are also called to account at the Health Portfolio Committee in terms of our performance issues. Thank you, Chair.
Thank you very much, Ms. Padayaki, and welcome, Member Rava. Yes, we did note your apology. The presentation really is very informative. It was just to lay the scene for us members so that we understand the environment. It was not as direct as the other presentation would be, but at least, because if our minds are at the right place and we understand now how the environment works and how professionals are supposed to conduct themselves, because we understand some of these medical legal claims might also lead to negligence, and some professionals might be unethical in their conduct. So at least it was just giving us that idea. But I'll hand over to Member Hickling. I see your hand is up, and Member Klaba, you can continue.
Thank you so much, Chair, through you. Ms. Padiachi, thank you so much for your very interesting presentation, and I welcome it from a personal perspective because I have my own case for medical malpractice. But I would like to pose a question to you. I live in Madantsane in the Eastern Cape. I have a cerebral palsy child who became cerebral palsy through hypoxia at birth, and I am technically struggling with literacy. I am an indigent person, and I want justice for my child. I don't know about the processes that you as the HPCSA could potentially offer me. Somebody comes to me and says to me, there is a mediation process and we can get you assistance because I don't have the money to go to court. And I say, okay, I will do anything to get assistance for my child who is now in a wheelchair, bed-bound, whatever the serious implications are, to further medical care for my child. I now get put into a situation where there is a mediation process with the HPCSA, and I'm using you because this is the organization that you represent. And I am told that I can bring somebody with me because my English is not fantastic, but my isiZulu or my isiXhosa is great, and I bring somebody with me so that they can translate for me to ensure that we are all on the same page. And in that mediation process, stuff is said to me that I don't understand. And I refer to my colleague who I've brought with me, who just happens to be a lawyer. And because the HPCSA finds out that I have brought a lawyer with me, my case is thrown out. How do I proceed in getting justice for my child, because the person that I've brought with me who happens to be my brother happens to be a lawyer, and I've brought a person that I trust into that mediation, not because he's a lawyer, but because he happens to be my brother. And I'm speaking to you about an actual case that I know happened. We need to get a system in place where mediation becomes equitable for everybody. I'm not talking about myself, who may be very medically literate because I am. I'm talking about a really indigent person who needs the assistance of the HPCSA because she has been failed on other levels, and who needs assistance to get justice for her child. How do we go about ensuring that that becomes the focus of the work that is done by the HPCSA to help our residents? Thank you so much.
Thank you, Chair. Good morning to you, Chair, honorable members and colleagues. My apologies again for being late. Thank you, Ms. Padiachi, for your presentation, and the committee welcomes the initiatives as medical claims are a major burden on the finances of the public health system. I have a question. You've mentioned the collaborations that you have with health regulators. How is HPCSA aligning or collaborating with the Provincial Treasury and the Department of Health? And if there are any collaboration, what is the success rate? And the second question is, you've mentioned withdrawals. So in a case where a complainant decides to withdraw the case, who is responsible for the legal cost? What are the cost implications in a case where a complainant decides to withdraw the case? Thank you.
Thank you very much, members. Member Padayaki, I guess Member Hickling was giving you an example, but also I think what she's emphasizing is, are you in a position as HPCSA to look into the mediation process and if there are legal people? So I think you just need to respond in general. But also I think your presentation mentioned that those complaints that you were mentioning, just wanted to know whether they are national or provincial. And I'm not sure now if you'll be ready with the information, or maybe we will receive from the other presenters just to check, is it which hospitals and clinics that you mostly have complaints and whatever, because that will also give us an idea. I want to place this on maybe all the presenters, the question that I'm going to pose now, just to have an understanding that for the department to deal with medical legal claims and those accruals, which experts, in terms of the team, would one need to have, so that then they give inputs on responding to these claims? Because we want to be able to also assess whether as a department, maybe in the Department of Health in this province, maybe unable to deal with some of these claims or accruals because they have not considered a lot of experts that must be involved in determining, the case. So it's just for my understanding, which skills would they need to have for them to handle these cases? Yes, Mepadak, you can continue. Thanks.
Thank you, Honorable Chair, and thank you, Honorable Members, for the comments and the question raised. I think in respect of the first one, where the attorney was involved, maybe if I can ask the Honorable Member to provide me outside of the meeting with specifics relating to that case, I will definitely look into it. But generally, what I do know that we've put in place now is where the practitioner is represented, the legal representative is actually present, is invited, or similarly in the case of a complainant, the legal representative is present, and there's the mediation process actually sets out the roles of the relevant parties, because it's to avoid the process from becoming too legalistic and to also avoid it turning into a situation where you're not bringing your case there to be fought. It's more opening up the dialogue and the communication between the respective parties with the intention of trying to resolve the dispute between the parties. But I would be very interested in the case that you mentioned and in terms of what really happened there, and I think then that would equip me to handle or to respond to the question more holistically. But again, I take the point in terms of, you refer to the area in the Eastern Cape, and the Eastern Cape is one of the areas I know that has a burgeoning medico-legal contingency liability amount. So we did also do a presentation at some stage to the Eastern Cape legislature as well, just highlighting some of the more general observations that we had. But in terms of making or raising awareness about complainants, we do have a comms team, a corporate communications team that goes out, and they do have programs in terms of which they're trying to reach all areas of, of a particular community, not just focusing on the urban areas, etc., or just focusing from a practitioner perspective. So we also do short presentations on radio, and we do it in different languages. We've identified quite a number of that. I can also provide statistics, but out of this meeting, in terms of how many radio campaigns we've done as well. We also have a unit which also falls within legal and regulatory. It's the inspectorate division. So the inspectorate division is responsible for basically checking where practitioners may be suspended but are still practicing. So they're not supposed to be practicing, they're practicing illegally. So where we know of suspensions or removal from the register, and we do random spot checks. We can't do it, of course, to every practitioner, because when there's when practitioners don't pay fees, then there's quite a large number of people who may be suspended. But we do random checks. So when the inspectors also go out, they also look for unregistered practitioners, which the HPCSA has no jurisdiction over. So there we work in collaboration. Sorry, I meant to also include SAPs. We work in collaboration with SAPs. So when the inspectors also go out, and these are mostly in the rural areas, when they go out, then they also do some kind of community awareness in terms of the role of the HPCSA. So these are some of the initiatives, but I mean, there's always room for improvement. So we do welcome, constructive feedback in terms of areas that we need to improve on. So, Chair, sorry.
Can we just wait for her to
Sure,
conclude, and then I'll give
it was just a point of clarity.
Oh, okay.
My question was not necessarily on that case. My question was to say to you, how available is the HPCSA to indigent South Africans as opposed to your average urban South African? That was more the point than the case in Madansane. It was just an example. Thank you so much, Chair.
Thank you, Chair. Chair, I think I've responded in terms of some of the radio campaigns, and then I just demonstrated that when our inspectorate unit does go out into not the urban areas, because we find unregistered practitioners largely in the areas outside of the bigger urban areas. So we do awareness there. And again, I said, there's always room for improvement in terms of reaching, the greater population in outlying areas. Chair, in terms of the collaboration, the member asked on the collaboration with you referring particularly to the Gauteng Department of Health. I do know that if there's a specific request, for example, in terms of any particular matter that would require intervention, we do reach out. But our collaboration mainly is with the national department in terms of the direct mandate. But we don't have any specific collaborative efforts or initiatives unless, like for example, today's initiative, we were invited. So we are available to do that as well. In terms of the withdrawal of a case and costs, again, there are no costs which are incurred when a complainant registers a complaint with the HPCSA. The costs are borne entirely by the council, and if the complainant withdraws a case, the complainant does not bear any costs. So the whole costs of complaint processing right up till the professional conduct inquiry level is borne entirely by the council. The respondent, of course, will bear his or her own costs if they obtain legal representation. but there are no cost implications. And Chair, you asked a question in terms of, and if I may get you clear, the figures that I've looked at, we have presence in some of the provinces in 3 provinces in terms of our inspectorate, but the figures that I've referred to are national figures, they're not provincial. In terms of hospitals and clinics, Chair, I think we would need more time to provide that information. But I also want to indicate that in terms of complaints, almost 90% of our complaints come from the private sector. In terms of the public sector, there are complaints not largely around negligence matters, but there are issues, complaints around RWAPs or practicing whilst not being fully registered with the council, etc. So maybe in terms of reporting, we don't see that as prevalent from the public sector. In terms of the experts, Chair, I think I'll leave that to the 2 experts on my left and right who are more familiar with the topic. Thanks, Chair.
Thank you very much, Mayor Padayaki. You are welcome to stay for the rest of the presentations. And yes, I think the discussion really has been very empowering. Yes, you may provide us with more details, and I think there's one also where you also said you'll give us more information to Ndate and Zane. So we are now moving on to the next presentation. I think it's from the SAMA, South African Medical Association. And we do understand that the association, your interest is to serve both the public and the private, professionals that are serving in the private. So if you can just take us through your policy as well. Thank you so much.
Thanks so much, Chair. Good morning, everyone. Thanks so much for this opportunity. We really appreciate given this opportunity to provide our view. We were asked specifically to...
You may introduce yourself, sir.
Oh, yes, of course. Sorry, I'm coming to that part too. I'm Dr. William Westhuizen. I'm the Head of Legal Affairs at the South African Medical Association. So thank you very much for the opportunity, as mentioned. We were asked specifically to look at the policy and our advocacy efforts surrounding medical legal claims. Let me first start with SAMA's role and mandate. So we are the National Medical Association, the largest and oldest doctors' representative body in the country. We represent practitioners across both the public and the private sector, as the Chair had mentioned. Our members include medical students, interns, ComServes, MOs, registrars, consultants. That's public. In the private, of course, we've got GPs, specialists, subspecialists. So from the start of your career all the way through to you becoming a professor and eventually retiring, whatever the case may be, we represent any and all doctors. So we advocate, of course, for their professional and ethical interests. We promote sustainable, equitable, and high-quality healthcare, and we engage constructively with government and stakeholders. So on the medico-legal crisis, I think we all know that it is a dire situation. I'm sure we'll get the figures from the Auditor General when we're joined. It's the frequency, it's the amount of claims that have increased incredibly. The contingent liability, of course, threaten the fiscal stability of provinces. I'm sure that's the case for Gauteng as well. And this unsustainable cost burden eventually undermines service delivery and, of course, patient care. But we'll, I'm sure, hear more about that from some of the other speakers as well. Some of the challenges in the public sector, I think we're also well aware of some of those challenges, which is, of course, the poor state of infrastructure and facilities. Understaffing is a big one. Mismanagement, corruption. I'm sure all of us saw the various blue Lamborghinis that were rolled out of a person's residence quite recently. The absence of leadership and stewardship is also quite a significant problem, and all of this contributes to an environment that makes adverse events more likely. Claims have a severely detrimental effect on provincial health budgets, and of course money that gets spent on claims is money that cannot be spent on improvements to the system, and that perpetuates a decline in quality and leads to a vicious circle where poor quality leads to claims, that leads to less funding, that leads to poorer quality care, and it all happens again. Recent cost-cutting and austerity measures have also had a detrimental impact on the system. So, of course, there have been moves to cut costs, but it might be a case of short-term gain, long-term pain. So what we've seen recently, of course, is the termination of commuted overtime, but this has an effect on training. We've seen vacancies that remain unfilled. The unavailability of medical officer and registrar posts, and at the end of the day, it's the patients that suffer when the healthcare system isn't resourced in the way that it should be. As mentioned, patients, doctors, and the healthcare system suffers in the end. Looking at the private sector, unaffordable increases in indemnity insurance costs. The high-risk specialities have seen staggering increases. This makes it unaffordable for those young doctors who start out in their careers, especially if they wanted to go into obstetrics or some of the other high-risk areas. Those who can afford it might also shy away from some of the higher-risk procedures. The chair mentioned earlier the possibility of defensive medicine and the possibility of this limiting access to care, which is also quite a real threat. And these additional costs, where they can't be absorbed, are probably pushed onto patients, leading to more expensive care in the private sector, which also is quite detrimental. Coming to the flaws with our current malpractice system, which is the main way in which injured patients are able to obtain compensation. From the start, I wanted to be known that patients who suffer injuries should be assisted and compensated. But the current system with which we do that is severely flawed. It is very, very expensive to administer. A fraction of the cost spent on this system actually reach the injured patient. Estimates in other countries have indicated that as much as 70% of the money spent on the system is legal fees, so it doesn't really get to the injured patient. The system is also poorly suited to the complex nature of medical practice. So where systemic issues are mostly to blame for these injuries and adverse events, the system places blame and targets individuals more often than not. So those systemic issues remain unaddressed. To an extent, I would argue that it is detrimental to patient safety because it does nothing to really improve the quality of care. The deterrent signal sent by the system is very weak. It, as mentioned, targets individuals. It takes years for an issue to be resolved. It leads to an environment of blame and fear, where these systemic issues I've mentioned are likely to be concealed rather than be disclosed, to be learned from in order to avoid liability. It is also adversarial, pitting the patient and the patient against each other, which completely contradicts the trusting doctor-patient relationship that would have existed immediately before the adverse event taking place. Of course, there are doctors that don't practice ethically. I would hope that they're not SAMA members. And this doesn't necessarily apply to them. Those doctors definitely should be held accountable for negligent and reckless and grossly negligent treatment. But the system certainly can be improved. As we've also come to know, it's vulnerable to abuse. The SIU SIU's findings is an example thereof, and we've all seen the carte blanche episodes where injured patients don't receive a penny of the amounts that get claimed and gets owed to them, and there are some real unethical legal practitioners walking around with the money that should have gone to those injured patients. So we believe that a more efficient, cost-effective, and patient-focused compensation system is required. And this brings me to our policy and advocacy work, and I'm very glad that we've got Ms. Ronell in the room, because she has done absolutely incredible work. Those of you that have perhaps read previous versions of Project 141, she has outlined this entire situation. There are recommendations in there. Countless stakeholders have made inputs, but unfortunately there hasn't been much progress on that, and I don't think it's because of a lack of trying from the Law Reform Commission side. It's probably the Department of Justice and others that should take this forward. And of course, we've also recently contributed to the Alternative Dispute Resolution Mediation Act for South Africa, providing our inputs on that, and there are the mediation uptake in the courts here in Gauteng, etc., which is also a positive step. Some more of our practical interventions from SAMA's side. We've established a SAMA ADR unit with mediation in motion mediators to try and mediate some of these patient disputes. So we try and advertise this as broadly as possible, but I have to admit that unfortunately the uptake hasn't been great. We've got a pilot system currently in place where the patient nor the doctor pays anything, just to try and entrench mediation amongst our doctors and patients, and to try and see that we get to resolutions that are more fit for purpose, rather than the adversarial hostile environment that one often sees when the litigation route is followed. So we're trying to push that, but as mentioned, uptake hasn't been what we've wanted. We also participate and present clinical and ethical CPD programs. As my learned colleague to the left has said, we do this to try and equip our doctors with the knowledge and skills to help them improve care and make claims less likely, to try and foster a safer and more accountable care environment. So what we believe are some of the root causes and some of the recommendations that SAMA would have is there seem to be governance and infrastructure failures. There's insufficient human resources. Earlier this year we had almost 2,000 unemployed doctors, which is just shocking in a country such as ours that desperately needs that care. There's a weak patient safety culture, I've alluded to that. And we've got a very strict litigation-based compensation model that might not necessarily be aligned with the goals of compensating patients and creating a more patient safety forward environment. Some of our recommendations, and again, I would refer the colleagues to the wonderful work done by Ms. Ronell, is to move to a different sort of compensation system, to institutionalize mandatory mediation, to align our systems to prioritize patient safety, to invest in clinical governance and training, and to align fiscal planning with risk mitigation and strengthen our data and reporting systems. As a conclusion, I think we all know that the medico-legal crisis threatens sustainability and trust. This isn't just a financial issue, it is a human and a systemic one. SAMA is ready to partner with Treasury, Health, Justice, and yourselves. And again, thank you for inviting us. And our goal is to restore patient safety, accountability, and fiscal sustainability through some of the interventions that we've proposed and through some of these partnerships that we hope will continue from here on out. Thanks so much. Thanks.
Thank you very much, Doctor, for that presentation. I think maybe just to add, before I hand over to members to also make a comment, you know, the reason why we also requested that all three of you must come and do the presentation is in as much as we do realize that there are, you know, inefficiencies and challenges in the health environment. But also, I think that's the reason why we also requested that we have a presentation that sets the scene, because we do also realize that because of such environment, then some would see an opportunity, you know, to use the space, especially, you know, whether it's in the legal advisors or experts, whether it's other medical doctors that they would club in, you know, and then they do take, you know, these opportunities, and therefore it also leads to a burden on the healthcare system. Hence, you know, it's very good that it is regulated. Like, you know, with the REF, you know, the accident fund and all that, people would use opportunities and this as well. So we felt that it maybe that's the reason why you would have that, and you're wondering why there's so much accruals and it never gets to an end, you know. And obviously it does have a burden on the system. Member Hickling and Member Cobb.
Thank you so much, Chair. Thank you, Dr. Oosthuizen. I want to just contextualize something for you about me. I am the DA spokesperson on health and finance. I'm also very medically literate. I'm the editor of a nursing journal, and I'm the copy editor on 8 nursing textbooks. So my medical knowledge is in many ways more than my finance knowledge. But I'm approaching this from a finance point of view because this is the committee that I'm sitting in at the moment. The fiscal drag of medico-legal claims is phenomenal in terms of the damage that it does to the coming or the next year's financial ability for a health department to actually function. And we need to find a way in which to reduce the accruals so that it doesn't impact the operational budget of a health department. And with that in mind, the workings of SAMA are very, very important for us. And I had hoped that the chairperson of the Health Portfolio Committee would have been here today because he was invited. But I am going to strongly motivate that SAMA does this presentation to our Health Portfolio Committee. Because the problems that we see in infrastructure, the problems that we see in human capital, directly impact the level of medico-legal claims that the Gauteng Health Department faces on an annual basis. And when you have the previous head of health coming in December of last year and going, we managed to dispense with 840 cases, we declared them dormant, medico-legal cases. That was 8 billion rand that we saved. And I put my hand up and went, how do you declare 824 cases dormant? It's just not possible that all of a sudden 824 cases become dormant. There is a serious problem with ensuring that cases do not become dormant because there is no ability for a litigant to continue with the process because of the costs associated with it. That is number one. Number two, I don't think I have to tell you about the Noyile judgment. Do you know about the Noyile judgment? Yes, you do. Chair, for your benefit and for the benefit of the other members of this portfolio, there was a judgment that was made in a case of a cerebral palsy child. He's no longer a child, I think he's 11 years old, and his life expectancy is 22 years. His mother was turned away from a clinic when she was in active labor. To cut a long story very, very short, when she actually delivered the child, he was so severely brain damaged. He is bedridden, he is, to all intents, he's microcephalic, his brain did not develop. The damage is extensive. And the judgment, instead of awarding him or his mother money, said, you can bring him back to the hospital that damaged you for further treatment. But if you move, we will stop all treatment. Really? That was just beyond anything for me. What can SAMA do in a case like that? Because that cannot be allowed to happen. We cannot have more Noyile judgments. To my knowledge, that has not been put into place or tested, because I know of one of the attorneys who was involved in that case, and there is a whole bank of attorneys waiting for that to really be enforced, and there will be a bloodbath. But the problem is, we as the finance portfolio have to try and work with SAMA to address how we can stop challenges like this happening, how we can stop judgments like this happening, and how SAMA can advise us, to advise Treasury, to advise the Health Department, to employ more doctors, to fix infrastructure, because that is the only way in which we're actually going to address this. We cannot have a situation where at the end of the year, if you pay all your accruals, if you pay all your medico-legal bills, you will have no money for the following year. And I don't know how to do that. I don't know how we can do that. And I don't know how you can assist us to assist the Health Department. And I'm only talking about Gauteng. I wish I could solve the problems of South Africa, but let's confine ourselves to Gauteng, because those are the challenges that we find as the Finance Committee. How do we advise Treasury in Gauteng to advise the Health Department to stop these kind of practices? Gauteng Health Department says they have lifted the moratorium on the freezing of posts. They haven't. There still are not enough doctors. There are not enough nurses. There are not enough allied health professionals. And it's a problem. So I don't know what the answer is, but I would love to be able to get you to work with us, with the Health Department, to try and address this. Thank you so much for indulging me, Chair.
Thank you for that, Member Hicklin and Member Klaver. Do you have any?
Thank you, Chair. Dr. Westhuizen's recommendation, he highlighted a need to align fiscal plans with risk mitigation. And I'm sitting here, Chair, thinking that is there a possibility as a province to have a contingency fund or something like a insurance model or a designated reserve for medical legal claims or settlements to reduce the pressure or impact on the provincial health budget? As much as the root causes have been highlighted, they've been analyzed, but at the end of the day, we need a solution in terms of these medical claims and the accruals that are a burden to the health department's budget. I mean, 60% of the budget goes to accruals, and the bigger chunk of those accruals is medico-legal claims. So one of the recommendations is that we need to align the fiscal plans with risk mitigation. So it's a pity that there is no representation from the Department of Health or from the Health Committee, you know, so that such contingency plans can be deliberated and be discussed. Because as much as we can dwell on the root causes, the challenges that are faced in the public health system, but we need solutions. Thank you, Chair.
Thank you very much, Member Klava. In fact, your point leads me, that when he comes back, and Mechilon, if you could take the point. Remember when we went to the NCOP and we were doing a study on the Parliamentary Budget Office, which we have not yet implemented here, but there is an opportunity for us to submit such recommendations to the appropriations, the select committee, so that when they do look at the DORA, and when they do that, then we should be able to. I'll request that Ntatanzane maybe sends that recommendation, especially coming from here, so that we submit that for them to look into. So this really it's not just a discussion in veil. And also, I think, yes, I'm happy that Member Hicklin also serves in the department, Health Portfolio Committee, because then these collaborations are very important. In fact, we were very mindful with the officials when we were drafting this, and also inviting stakeholders that were not seen as overreaching into the health. Even the adverts that we're sending out, we're saying we're talking about medical legal claims. It must not just end at claims. We are looking at medical legal claims because they lead to accruals. So that is our interest as the Finance Portfolio Committee. So therefore, I think we welcome the fact that you will be able to give input into the Portfolio Committee of Health, and also motivate for and lobby for the stakeholders to also come and present there. The chairperson of health, really, had invited him, but it was only extended yesterday. So, because it was really a late, yes, so it was a late invitation, but at least there is an opportunity for you, Member Hicklin, and we are lobbying you as this Portfolio Committee, because that was the reason, because we wanted the committee to also understand this, so that when we engage on that side, and when we're engaging the side as well, there is that alignment, and we're able to come to the end, because it does not help when Portfolio Committee of Finance is dealing with the medical legal claims, but there's no assistance from the other side to also make sure that we look into this health risk and mitigations. So yes, I don't know, I will hand over to you, Doctor.
Thanks so much, Chair. And just to say to the members, I can't agree more. The Honourable Member Hicklin, with what you've said, anytime, more than willing to partner with definitely. This is a difficult problem. You're going to have to look at a multi-pronged approach. You definitely need to address the root causes of it, though. It doesn't help only coming in at the back end and limiting or capping claims that patients may have. For instance, there isn't justice in that. You also alluded to an example. There isn't justice there. So SAMA is more than willing to help in any way that we can, be it providing clinical expertise, looking at how we can really try and improve patient safety, not just give lip service to it as something that someone's included in some annual plan, but to really dig down and try and prevent these adverse events from occurring in the first place. But it needs to have a systems approach. If we continue to blame individuals and have those sort of interventions, we won't see the changes that we need to see in the system. And the other honourable member also in full agreement with what you've said. So looking forward to working with you and collaborating with you in any way that we can. Thanks so much.
No, thank you, members. Let's note the two presentations. We're now going to move. I know I was requested that we may maybe break for lunch, but I just think we must take this presentation before we go for lunch and deal with other business of the committee afterwards. I think we still have time. So when we requested the South African Law Reform Commission to also come and make a presentation, because we wanted to look at improving healthcare and claims processes and whether there are alternative dispute resolution methods. And I think the Mayor Padayaki also took us through that. Pre-action protocols and certificates of merit, court process reform. We have, I think Member Hicklin also came and had an input on the mediation processes, whether those can be done. Shift from compensation to redress, whether that is possible. And take us through the overview on the legislations, efforts and development. I will hand over to you, May, to just take us through that and maybe respond to some of the questions that I said. I think we would, okay, thank you so much. Which one? An overview of the legislative efforts and development focusing on state liability amendment bill 2018. That then Zane is saying, please emphasize on that. Thank you so much. Please go ahead.
Thank you, Chairperson and honourable members, and everybody else present. Let me not forget that the supporting people are equally important. My name is Ronelle van Zyl. I'm a state law advisor at the South African Law Reform Commission, and I was the researcher responsible for doing the research and drafting the research papers and the final report with regard to Project 141, Medicolegal claims. I have to just explain something. This is the final report. It's over 600 pages. It includes 2 draft bills. Unfortunately, I cannot speak to it. The reason being it's not in the public domain yet. We have finalized the report in terms of the South African Law Reform Commission Act, which creates the statutory body, the South African Law Reform Commission, the members of which are appointed by the President. We have to submit our final report to the Minister of Justice, now currently designated as the Minister of Justice and Constitutional Development. And the Act says we must submit it to the Minister for consideration. The practice has developed that the Minister then gives us the go-ahead for when we release the report publicly. In the case of this report, the Minister has indicated a wish to have a media briefing together with the Minister of Health, at which time the report will be released, formally handed over and released into the public domain. And we have not yet received a date for the media briefing, which is terrible because last week alone I received 4 inquiries about the report. Everything that was listed in the letter that was sent to us last week is addressed in this report, but I can't speak to it. But what I'm going to try and do is to come up with some of the background and some of the issues that inform this investigation, and I also try to specifically address the matters that you listed in the letter. And I'm also, I was told that I can do this, is to just point to specific problems, and I know you're very aware of the problems, but I think people sometimes forget just how serious these problems are. And there are some matters that I would like to talk about to illustrate one of the biggest issues here, which is lack of implementation. But let me get into my formal presentation. As regards to the background, as I've indicated earlier, the South African Law Reform Commission Act was established under, or the South African Law Reform Commission, the statutory body, was established under the South African Law Reform Commission Act of 1973. So we're over 50 years old now. The commission was established along the lines of law commission agencies across the world, especially in the Commonwealth countries, the first of which was the Law Commission of England and Wales, which to a great extent informed the structure of our act, but we're actually currently reviewing our act to update it and to modernize it. So in terms of the Act, the main object of the Commission is to do research with reference to all branches of the law of South Africa and to study and investigate all such branches of the law in order to make recommendations for the development, improvement, modernization and reform of the law. This particular project, Medicolegal Claims, was included in our research program subsequent to requests from the Minister of Justice and Correctional Services, which was the minister's title at the time, and the Department of Health. And the main reason for this request was the exponential rise in medical negligence claims against the state, the financial impact of such claims on the fiscus and medical negligence case law. At the time when we received this request, obviously it was about claims against the state. From the responses that we've received to the two research papers that we've published for comment by members of the public and stakeholders, and the workshops that we held as part of our public consultation process, it's also very clear that there's also a need to look at medico-legal claims in the private health sector. This investigation was already quite comprehensive and took us a long time to deal with because it's such a broad topic. But we have actually indicated that we could consider doing a second leg of this investigation to particularly look at claims in the private health sector. And I know, and there my two colleagues can correct me if I'm wrong, but I know two of the issues that really causes anxiety in the private health sector is, on the one hand, the possibility of criminal liability, which we also are looking at currently, and I'm also the researcher responsible for that. And the other issue that concerns private health practitioners is the high cost of insuring themselves and indemnifying themselves against medico-legal claims. So those are two concerns that's very foremost in the mind of private health practitioners. I just want to mention that. So going on to the next slide. Looking at the background of medico-legal litigation, the extent of medico-legal litigation against the state has reached a level where it's adversely and prejudicially impacting in a serious manner on service delivery in the public health sector and endangering the constitutional right of access to healthcare services. And that's a very real concern. In terms of the Constitution, the state has a constitutional obligation to take reasonable legislative and other measures within its available resources to achieve the progressive realization of the right of access to healthcare services. Healthcare services is one of the so-called socio-economic rights, which our Constitution being quite a progressive Constitution in global terms, where we expressly protect the socio-economic rights in our Constitution as well, which is not generally the case in other constitutions. So in that regard, we are quite progressive. And there's been numerous court cases where this principle was tested and the limits of this was tested. So it's been firmly entrenched in our law that we do protect socio-economic rights and, what should be done in that context. Then, what has become abundantly clear over the past 2 decades or so, is that the existing common law compensation system does not effectively balance the right of claimants with the state's available resources and does not make general provision for alternative compensation methods. Next slide. So we've recognized that there's a need to achieve the following. We must simplify claims procedures and reduce disputes. We must try to establish procedures for the expeditious resolution of valid disputes that may arise. We have to alleviate the burden on the courts. We all know just how dire the situation in the courts are in terms of the length of time it took for matters to actually be enrolled with a court, and then eventually for the final result to become available. And what's very important, we have to balance the needs of injured persons with available state resources. And there's no choice about whether we should or could. We have to, because the state, we all are very well aware of the fact that the state has limited resources. As much as we would like to have these wonderful plans for compensation, we simply cannot afford it. So what we have to do, we must afford victims of negligent medical treatment by servants of the state fair compensation. But that compensation must optimize limited state resources while affording reasonable and appropriate healthcare services and other services, and providing financial support to persons affected by negligent medical treatment by servants of the state. Next slide. So what are the problems in the public health care sector? I can refer you, I have mentioned that we follow a process of broad public consultation when we are conducting an investigation. We normally, during the course of an investigation, publish 2 research papers. The first one is an issue paper where we actually just sketch the problem, look at the scope of the problem, and request people to give us comments on whether we should expand, contract, focus, whatever our investigation. And then we publish a discussion paper, and in the discussion paper we come up with preliminary proposals on how we think the problem could be addressed. We often include proposed draft legislation, which we didn't do in this case, because at the time of the release of the discussion paper, the proposals wasn't, I almost want to say it wasn't formed to an extent yet where we could come up with proposed legislation. But in the draft report, we now actually are proposing 2 bills to deal with this. So apart from the comments where members of the public and I received comments from the private health sector, the public health sector, from provinces. We received comments from the legal fraternity, from academics, from organizations such as SAMA, SAMLA, various medical organizations. So we really had a very broad, the insurance industry, MPS, the Medical Protection Society, and Ethical comes to mind, which are the 2 biggest providers of indemnity to health practitioners. So we had a very broad array of people that commented. But apart from that, when I was first assigned this, and it was actually at my request because I'm very interested in medical law, I was a bit worried about, I'm a legal person, how will I be able to look at and judge medical-related issues? That's not my area of skills or expertise. But I then discovered that there is literally a myriad of reports that's been done, and the earliest goes back to 2003, that looks at the quality of public health, the problems in the public health sector, etc., etc. The biggest single problem with all these reports are non-implementation. That we tend to do the same investigation roughly every 2 years. There's another investigation that very often comes up with quite similar recommendations to the previous number of reports. They never fully implemented. And I almost want to put lack of implementation in big fat capital letters across my report, Because as much as we can propose the best legislation that we can possibly come up with, and South Africa does have excellent legislation, as much as we can propose the best legislation, that legislation is not worth the paper that it's written on if there's no implementation. So again, it's no use. And sometimes I see people even come up with legislation to try and find ways for previous legislation to be properly implemented. Or policies, or whatever. So that's really a major issue here. I'm not saying that there isn't a need for new legislation. There definitely is, after I've done this investigation. But a lot of the problems can already be addressed by just implementing existing legislation and monitoring that it's actually being implemented. And another big caveat here is accountability. A lot of times the problems occur and the problems continue because people are not held accountable if they don't follow the correct processes and procedures. And financial procurement, that sort of thing, is a big part of it. I mean, Dr. Oosthuizen has mentioned the Lamborghinis. The Lamborghinis are the least of what was impounded. The property of, I think it is an 88 million property, for example, is much more relevant than just the 5 Lamborghinis. And I found it interesting that they were all the identical blue, same color. So obviously it was the favorite color of the person concerned. So, I mean, just the mere fact that at one hospital, over a number of years, there were 2 billion, which has been now flagged, in corruption, makes one wonder, if you add up all the corruption across the whole of the country, how much better our public health care services could be if that money is made available for legitimate purposes. But we are all aware of those problems. But in terms of the source material that I looked at to also highlight the fact about these problems and what these problems are, there are reports by Chapter 9 institutions. There are the annual inspection reports by the Office of Health Standards Compliance. There are several government-initiated reports. There's the Redzitse reports that all flag things like human resources, staff shortages, that include shortages of supporting staff, such as data capturers and cleaners. They highlight skills and capacity of staff and staff attitudes. I'm sure you're all familiar that there was a presidential health summit on Medicolegal that took place in 2018. The report of that summit was published in February 2019. And quoting from that report, the health system is plagued by endless challenges relating to inadequate funded posts, maldistribution of posts relative to need, poor service delivery planning, clinicians who are overworked, safety concerns for staff and facilities, lack of financial resources to absorb junior doctors in the public health sector, etc. What they also indicate is that the organizational design in hospitals and clinics is characterized as top-heavy, with many managers appointed and the duplication of roles. The increase over the past, the first report that specifically raised this issue was the 2009 report, and I will refer to that later, where they actually gave the percentage of how much medical staff was reduced in the public health sector and the increase of administrative and especially managerial staff. And I, at one time, attended the Health 10 by 10 meeting. For those who are not familiar with what this is, it's the legal and mainly the financial people of National Treasury and the provincial treasuries that come together with the health sectors, where they specifically discuss the health budgets, health financial issues, and so on. And at one of those meetings which I attended, where I had to do a presentation on this project as well, it was particularly flagged that the health sector is top-heavy. There are too many chiefs, not enough Indians. Too many people that are managers that are not adding real value in terms of operational issues, but that actually just increases the red tape the bureaucracy without really adding value. Not to say that there shouldn't be managers, but there must be a realistic relationship between the managers and the operational staff. Like I said, lack of implementation of existing legislation, corrective measures, reports, etc. Some of the issues raised by people that commented on the issue paper and the discussion paper was decline in professionalism among healthcare practitioners, poor management, lack of supervision and oversight, lack of accountability, allegations of a rise in the incidence of negligence, decreasing quality of care, lower standards of healthcare, excessive workloads, staff burnout, low staff morale, bad attitude of staff, sleep deprivation, and an under-resourced public sector that lacks strong management in many areas. There is poor oversight and management of persons performing remunerative work outside the public service, the well-known RWOPs that we always refer to. That's what that acronym stands for. As well as public health sector nurses that moonlight in the private sector on those 2 days that they often have off in a week. I've had this, it's anecdotal evidence, but I heard it from a person who works at a public sector hospital and whose wife is a manager in the private health sector, who says, I can't keep the private hospitals open without the public health sector nurses. There's nurses that get onto a bus in the Eastern Cape, travel for a night to come to Gauteng, work here in the hospitals, in private hospitals, travel back, and then they sit and sleep when they get back to work because they're tired. And it happens. It happens. With regard to the RWOPs, the principle of RWOPs is not the problem. It's the oversight of RWOPs. If a doctor works 5 days a week during normal office hours and then elects to have a private practice on a Saturday, that's not a problem because it doesn't interfere with the doctor's work. But what now happens, and unfortunately the managers, the clinical managers in hospitals who are supposed to oversee this, do the same thing. So instead of being at a hospital looking after state patients, that practitioner is, during a weekday, during hours when they're supposed to be at the hospital, they're running their private practice. So they're not there when a crisis occurs. They're not there to oversee junior registrars who are still in training. They're not there when nurses don't know what to do and need guidance. And that is not managed effectively. I understand the reason why they allow people to do this, because many people in government are highly skilled. You have your academics who are very often appointed in conjunction with universities that train medical practitioners, where one can understand that these doctors might want a private practice. It keeps up their skills, it helps them with an additional income, but it shouldn't be at the cost of the service delivery that they are paid for, that they must deliver in private hospitals. So that is a huge issue, is the proper oversight of RWOPs. And then obviously linked to that is our health system is a nurse-based system. It starts with nurses. So nurses moonlighting in the private sector and then comes back bone tired, that sits and sleep in the tea room during night shift while alarms are going off in the pediatric ward. And I mean, there were carte blanche programs where people filmed nurses with hidden cameras that proved that this was happening. They were sitting there because they were tired, babies were crying, alarms were going off with monitoring machines, and nobody was dealing with the issues. And then what's very important, medical practitioners and nurses are trained in the public health sector. There are some private hospitals that now do train nurses, but doctors, and please correct me if I'm wrong, all doctors are trained in the public health sector. There is not doctors being trained. So if the public health sector is going to implode, our entire health system will implode because our doctors all come from training in the public health sector. And South Africa presents exceptional scope for training. There are foreign doctors that come here for the training that they can receive. Our doctors are highly sought after in other countries, especially for the excellent training and for the trauma experience, which is maybe an unfortunate side effect from our fairly quite violent community. But in European cities, they don't have doctors that in one evening might treat patients that had been shot, been stabbed, been sliced with a bottle, who's been the victim of GBV. It's unfortunate of the violent community that we live in, but it is a reality that our doctors do have excellent experience and training, and the public sector doctors especially, because they deal with so many issues and with so many cases. So it's vital for our entire health sector that the public hospitals and the public health sector must function properly. I just want to highlight, mentions quickly, so sorry, I don't want, and I get, I've been told I'm very passionate about this, so. I just want to mention some of the reports, and I'm not even mentioning like the Redzitse reports that looks at clinics and the services that they offer, academic journals that's appeared. There's just, my list of sources, just academic sources, is very long, so I really can't, refer you to all of them. It's just not possible. There's just too much. That's why, partially why I battled with this, is to take this and to try and extract information that I can give you without going into the matters that I cannot talk about, but there's just so much information. There's the Public Protector report. Just the academic stuff on this one is over 200 sources that I looked at. That's apart from, the legislation, the case law, etc., etc. So just the articles and the books and the reports is over 200. Okay, so in 2020, the Public Protector of South Africa sent investigation teams. They conducted site inspections at various hospitals in Eastern Cape, Mpumalanga, KwaZulu-Natal, Limpopo, and Gauteng. It was an own initiative investigation based on media reports about poor quality healthcare. They looked at the quality of healthcare services, available human resources, the condition of physical infrastructure, availability of vital equipment and machinery, quality and availability of personal protective equipment, and staff morale, and they also looked at the impact of the COVID-19 pandemic. I discussed all those reports and highlighted some of their findings, and they were discussed in detail in the discussion papers. And I don't want to go into detail, but there were a few things that stood out to me, and it's the sheer waste of money. And since you're the Financial Portfolio Committee, you'll appreciate this. There was one instance of a hospital that bought a machine that, I can't remember the name of the thing now, but it actually can detect heart problems. That thing cost 17 million, something like that. 5 years down the line, it was still wrapped in plastic, hasn't even been opened, because they didn't take out a maintenance contract, and 5 years later, the guarantee on the machine has lapsed. It couldn't be used, it was never used, simply because they wouldn't enter with a supplier into a maintenance contract, which is almost, you can't have your local handyman coming to try and service something like this. It has to be the supplier. They never used it. So I'm sure that's one of many examples. So there's the infrastructure, the fact that hospitals are falling apart. What they often mentioned in these reports, the Public Protector reports, is construction work that was left incomplete. They would get people to do the building, so sometimes it was either the contractor wasn't capable of actually doing the work. In other instances, after a while, the province stopped paying the contractors, so they abandoned the project. So they have lots of half-built buildings all over at hospitals that was never completed because of this problems with procurement and payment. Same with food. Everybody has now contracted out food services. Sometimes the food is of such poor quality that the patients can't eat it. Or the province stopped paying the service providers, or only pay them a year down the line, which makes them go bankrupt, and the patients don't have food to eat. We all know about the linen crisis. I had a relative who was a member of a city's, of the council. The hospital, which was a general big provincial hospital in that area, had a machine that you put the linen in on the one end, it washes it, it sanitizes it, it dries it, and if you dry it properly, you don't need to iron it, it's ironed, it comes out the other end, and you can use it immediately in Kimberley. The last person who knew how to operate that machine retired. There were no contingency plan on training someone else. A few months down the line, that thing had rusted completely because it was left with stuff still inside, and they now actually send their linen to Cape Town to be washed and dried and sanitized. And that's just some examples. The South African Human Rights Commission did a number of reports. They did their first one in 2003 about Eastern Cape hospitals, but they did a general one in 2007 about access to healthcare services where they held public hearings. They also had emergency medical services in the Eastern Cape, and then they had the cancer treatment one in KZN. My report, the information obviously in the report goes up to a certain point. There has been other problems also with cancer treatment since then. The Special Investigated Unit, and I checked, and it seems to me that investigation is actually still ongoing, but I've heard that they will also come and address you. They're still busy with their report on medico-legal claims, it seems. I could only find preliminary reports preliminary updates that they issued in about August, September 2024. But they're also looking at the impact in the health sector, and it includes fraudulent claims. So I'm just going to mention the others that I found that had been done. The Clinton Health Access Initiative, and their costs were paid by Sweden, so it didn't cost us anything. They did, on the initiative of National Treasury, they did a report on Medicolegal. They did a Medicolegal claims analysis. We have the Presidential Health Summit report where there were, just everybody and their brother and sister were invited to this that had anything to do with medical. They came with a comprehensive report. They had different pillars where they, there was HR, there was ICT, so there were different topics where they made comprehensive proposals, and I think the COVID crisis intervened, and I'm not sure really how much of this had been implemented. There was the compact and the report that were related. The South African Lancet National Commission did an excellent report, which is titled "Confronting the Right to Ethical and Accountable Quality Healthcare in South Africa," where they also made lots of recommendations. That all of these, the public and private health sector. There was a comprehensive ministerial task team, hospital mismanagement and poor service delivery closure report. It was presented to the Portfolio Committee of Health in Parliament with 25 recommendations which the committee adopted. I have no real, I think practically we can see of what's happening now, that those reports, because they made lots of recommendations about proper management, procurement, quality, standard operating procedures, accountability, but look at the situation currently, which proves to me that these have not been fully implemented. I was part of this, the declaration following the Medicolegal Summit. There was a Medicolegal Summit in March 2015, organized by the Department of Health on the initiative of the Minister. We convened several times with lots of experts. We came with a declaration on particular issues that should be addressed and dealt with. I have no idea how far. We actually traveled to all the provinces and did presentations to all the provinces, the provincial health departments, on these recommendations. Again, I can't tell you how much has been implemented. There was a national litigation strategy report in 2012, which was a task team. They traveled, I spoke to one of the members, they traveled to various hospitals all over the country, looked at all of their medico-legal cases, and she said there were so many they could only do an example of cases. There were just too many for them to look at all of them. In the National Development Plan, there's a whole chapter on promoting health, and already in that document, which was released in 2012, they identify some of the problems that we are still battling with. And then the first formal reports was the reports of the integrated support teams. There were 10 teams, one for each province and a national one that compiled all of this. This was done at the initiative of the Minister of Health, which was Ms. Barbara Hogan at the time. It was paid for by the UK. Also excellent proposals. And I compared the 2009 report to the Presidential Health Summit report in 2019. And many of those issues are still there. But the one difference is the word corruption isn't mentioned once in the 2009 report. Now corruption is all over. So matters have actually deteriorated. I included the PFMA reports of the Auditor General of South Africa. I understand they will also come and do a presentation. And in the latest report that's available, the 2023-24 one, they state that continued high level of non-compliance means that most auditees have not institutionalized controls to ensure compliance with legislation. It's indicative of the non-compliance being tolerated with little consequences and a lack of management disciplines. And that's stated in the latest report. They started including specifically reporting on medico-legal claims in the 2016-17 report, where they stated that an emerging risk is the increased litigation and claims against health departments in most of the provinces. The departments do not budget for such claims, which means that all successful claims will be paid from funds earmarked for the delivery of health services, further eroding the ability of these departments to be financially sustainable, which was also earlier mentioned by William. In the 2020-2021 report, for example, they stated that provincial health departments paid out 1.76 billion for medical negligence claims during that financial year, while the estimated value of unpaid claims, that's now the contingency liability, which, you know, there's a huge difference, but that's about what might happen, was 124.15 billion. But that constituted 75% of the total claims against the state. And we all know that they're now claiming from the police all over and from other departments, but medico-legal claims are still the highest incidence. And they also stated that 7 provincial health departments had unpaid claims at year-end that exceeded their entire operational budget for the next year. And that's why accruals are increasing, because if all your money goes to paying claims, you have no money left to pay your service providers. They stop delivering services because they're not getting paid. We've heard of organizations that has gone bankrupt because they hadn't been paid for several years. So now I know that there are already organizations that refuses to do business with government because they simply don't get paid. They don't want to deliver services. In our own organization, our admin staff complain when they have to send out request quotations. She says there's a list that National Treasury publishes that they have to use. They consult those people. The people don't come back because they don't want to quote anymore, because it just takes too long to get their money. Just a bit more on the PFMA reports, which is number 3 of the PFMA reports. And the latest report on page 66, and why I'm saying this is because this almost exact paragraph appears in every report, I think going back to about 1819, because I looked at each year's report. This word for word almost appears every year. And the fact that it does appear every year indicates that it's not being resolved. Claims are made against departments through litigation for compensation as a result of loss caused by the department. Now that's generally, but the most common type of claim is because of medical negligence or malpractice by provincial health departments. Departments normally do not budget for such claims, and those that do often do not budget enough. The measures departments implement to manage and defend against medical claims are not always adequate. As a result, successful claims are paid from funds earmarked for service delivery, affecting departments' financial sustainability and their ability to meet their service delivery commitments. As in our previous general reports, we continue to highlight the need for the health sector to pay specific attention to medical record keeping, because claims often cannot be successfully defended without proper records. Departments then suffer further financial losses because they are ordered to pay interest on claims that are not paid out to beneficiaries by the time ordered by a court. Your interest can sometimes be almost as much as your entire claim. In the 23-24 report specifically pertaining to Gauteng, the province's financial health remains at risk as legal claims, being the potential payment obligations, continue to pose a financial sustainability threat. The Provincial Health Department accounted for 70% of this amount, with 64% arising from medical negligence claims, while paying the highest in the country. I think Gauteng and the Eastern Cape is sort of, it's almost like horses racing. You know, one has the nose ahead this year, and then the next one has the nose ahead that year. And that's medical negligence claims. Gauteng, probably because of the sheer number of people in Gauteng and the extent of the services delivered. In the Eastern Cape, there are lots of other problems. They're not the biggest problems, but there's many, and the rural nature of the province also definitely adds to this. So, suggested measures, and again, I wish I could talk about the legislation and our final recommendations. I cannot yet, unfortunately, and I'm very sorry about that. But I tried to take out the generalized things that's not so much in the legislation. Things that can be done already that doesn't require legislation. So firstly, one of the most important measures that the state must implement to reduce medico-legal litigation is to improve the quality of public healthcare services. And like William has said earlier, yes, we know the root causes of the problem, but it's no use knowing the root causes but not addressing the root causes. Because as long as we don't address the root causes, nothing is going to change. Implement existing measures. There are already, all these reports that I've now told you of, I didn't even mention the strategic health plan. There's an excellent strategic human resource planning that was published by the Department of Health a few years ago. Actually, that span of that report was until, I think it's 2020 until 2025. So it's actually now basically lapsed. And the previous one made equally wonderful proposals. Wasn't implemented. They addressed the entire spectrum of human resource issues in the public health sector in those reports. They came up with realistic proposals, not Cadillac proposals that we cannot afford. Not implemented. So, firstly, we have to look at all those reports, going back to 2003, look at them, see what hasn't been given effect to, look at what is consistently mentioned from 2003 to date, and come up with a plan on how to deal with this and implement it, do it, not just, because I get the impression that some departments think as long as you have your wonderful document on your shelf, you've done the work. It seems that there's no, once the document is there, nobody thinks that you actually need to apply this and implement this. Monitor it, hold people accountable for not doing what they should. Okay, yes, governance, management, accountability, financial management and oversight, which the Auditor General completely flags and have been for years and years past, which is what is very important. Do not defend indefensible claims and do not protract defensible claims. So if you get a claim and all your advisors tell you you cannot proceed with this thing, just pay out, just settle. There are departments that will obstinately keep on defending it. And if it is a defensible claim, they are so chuffed with themselves for being able to defend it that they also take years and years to take this through the courts instead of trying to settle or agree on what you could agree on and only taking to court those matters that you really cannot agree on. And that ties in with ADR and mediation. There should be a strategy framework for the conduct and management of medical legal claims and litigation. It seems that every hospital in every province does their own thing. There doesn't seem to be any structured plan, a cohesive plan that says, if you receive a claim, You do the following. You don't leave it on the edge of your desk and hope it will disappear, or that somebody will break in and maybe steal it for firework, to make fire or something. There must be steps. It must be referred to that person. What is the deadlines? When are you going to indicate that you're going to defend this action? What can you do? Can you negotiate? Can you defend it? Can you mediate? So there must be a specific step-by-step plan, and I've even included such an example in the discussion paper as a chapter, and it's now also here. A step-by-step proposal, it will have to be adjusted if the legislation that's being proposed is introduced, because it will change some of those steps. But there is a plan that provinces, I don't say they have to use it, they can use it as a starting point, but they have to develop how to deal with this, because so much time gets wasted because they just leave it until we either get a default judgment very often against government, or we have to pay costs because we've missed all the deadlines. And the state attorney is a big part of the problem. And just as an aside, it makes no sense to me to pay millions of rands for private legal practitioners if they just appoint capable people, more people in the state attorney's offices, because that's still the cheapest form, is to have your own in-house legal people. It's still the cheapest way. Not talking about counsel, you have to go external to get counsel. But why do you want to pay firms of state attorneys or firms of private attorneys lots of millions of rands if you can rather spend those millions and the state attorneys charge for what they do? They don't have to pay it out of the justice budget. You're supposed to get money for the services that you render. It just makes no sense to me that the state attorney's office has been so hollowed out, and there are so many problems in the state attorney's offices. But people now rather pay lots of money to private attorneys because at least something happens then. So I feel that must be addressed. Have a database. If you don't know what claims and litigation there are across the province, how will you identify duplications? How will you plan? How will you budget? So the first step is you must have the information, and you don't need legislation for this. This can be done immediately. Very, very important, proper systems of record keeping and preservation of records. Like if it's a child, if it's a disabled person, you can never throw that record away. You have to keep it because there isn't a limit on the period that a child can institute their claim while they're still in their minority. And for a disabled person and many cerebral palsy children, which is the majority of the claims in size and in number, are perpetually prescription will not run, because even when they turn 18, you still can't institute, that person still can't institute a claim. Prescription cannot run because very often those people are mentally disabled, so they're incapable of handling their own affairs, in which event prescription basically flies out the window. There are some of the commentators that said, no, bring in the 3-year prescription against children as well. It won't solve the problem because many times people are as adults that need assistance. So then there has been case law about it as well, and it's being interpreted expansively by the courts, because there is a provision about people being under curatorship, but the courts give the more liberal interpretation to that rather than restricting the interpretation. Provincial medico-legal units, and there's a reason why it says medico-legal, not just legal. There must be suitably qualified and experienced medical and legal practitioners. Lots of the medico-legal units have a few legal people, no medical people. They must have medical people. It's critical. Because one of the most important functions of medical professionals is to screen claims to determine whether claims have merit. I want to tell you a story about one of my advisory committee members. I'm sure she won't mind me mentioning her name because her name is mentioned in the report. Ms. Trudy Kaseki, she gave me excellent comments on the issue paper, so I said, would you please be an advisory committee member? Ms. Kaseki was a nurse in the public sector as well as the private health sector. And then she got fed up with being a nurse and she studied law. And she became an attorney. And as an attorney, she worked for a provincial department, Gauteng, in fact, the legal section in the health department. She actually was a member of she was an inspector at the Office of Health Standard Compliance, which meant she traveled all over the country to all kinds of hospitals to identify a problem and recommend what should be done. And she ended up being an attorney in private practice where she focused on medical legal claims. So she did the nursing and the legal stuff on both sides of private and personal. And she mentioned one of the things, and I'm sure it's not happening anymore. I know it was a while back, but she said one of her concerns, now because she had the nursing background, when she received a claim, she could look at it and say, I mean, I'm not talking about complicated matters where you need to consult expert. I'm talking about your normal run-of-the-mill. She would look at it, and because she has the health background, she could say, look, we can't defend this claim. It's very clear that we was negligent. And she was told, oh, no, counsel will take that decision. Counsel are the advocates that are paid per hour, paid per court case. You cannot leave that decision to counsel. You are the boss. You give counsel instructions on when and how and what to defend. You can't leave it up to counsel to decide we're going to defend this case or deal with this case or not, because counsel has a vested interest in leaving that case going for as long as possible. And to get their pals that are no longer doctors in practice but now only write medical legal costs, legal reports at exorbitant cost to give them some work. No, you don't leave it to counsel. The province must decide, and that's why they need capable people in a medical legal unit, where as a first line of defense, your medical people in your medical legal unit can say, this one, we are obviously negligent, we will have to settle. This one, these people are taking a chance, they don't have a claim, they will not win this. This one is complicated, we will need to refer to experts to get an opinion on what we can do here, because this is too complicated for me to make a judgment. I mean, even the private lawyers that specialize in personal injury cases have nurses working in their offices that screen. They told me, a private lawyer in this field, out of 10 people that come into my office with a medical legal claim, I take one, the one that I know I will win. And the first one to look at it is the nurse working there to determine whether there's an opportunity to win this claim or not. And it's become an industry. There are now people funding litigation. They get their money when compensation is paid. I will give you some figures if you think I still have time on one of the cases where I was able to get the actual figures of the costs on how little the child actually eventually received. Because everything in that award, out of nearly 19 million award, plus 7 million that was awarded for party-to-party costs, the child ended getting 3.5 million. All of the rest went to costs, all of it. Because the legal cost was the actual total legal cost was 19 million. More, that was just the plaintiff, more than the child's award. And there were exhausted evidence given in the case of what therapy and treatment and rehabilitation this child is going to need. The money is gone, it's finished, there's nothing. And they had the best plan. There was a case manager for the child. There was a well-known financial institution that was the trustee. So the money, the money was very well managed. But the little bit of money that was left over after all the costs were paid, what do you do with 3.5 million for a child that needs money for the next 40 years? It's barely enough for 2 or 3 years for that child to get. And so the child, eventually what happens with a lot of these cases, they just go back to the public health sector because there's no more money. Because all the money went to costs. Okay, so I've talked about those. Actively pursue early settlement of medical legal claims. A lot of the lawyers that commentated said, we try to settle early, nothing happens. And on the day of the steps of the court, as they say, the day of the trial, they settle. So for months and months and months, for years sometimes, this matter has been ongoing. You have to pay costs, you have counsel, you have medical legal reports. So if you could settle the day on the steps of the court, why couldn't you settle 5 years earlier when that claim was originally instituted? And the lawyers say, we come with settlement offers. And most of the time they ignore us. And that includes the state attorneys as well. But the state attorneys complain that they don't get instructions from the provinces, and the provinces complain that they don't get proper services from the state attorneys. So it's a bit of a, hopefully medical legal units can go some way, because if you have capable people in your medical legal units, and hopefully they're not given any other work apart from just dealing with cases, if you have capable people, they will support the state attorneys. If the state attorneys' officers are properly skilled, you will not need all this, and you can make an early judgment on whether to settle something or what aspects to try and settle. You talked about dormant claims. Currently, if somebody institutes a claim and it's just left open and they never follow it up, it remains on your books in the sense, in terms of contingency liabilities. So there is provision in the rules of court on what they call archive the matter. So I was at a workshop in 2023 where the Solicitor General and all the provinces were there, and they then actively said, we will look into our old cases that are on our books, but that's nothing, there's been no movement for years and years and years. To say that we are now archiving this because it's not going anywhere. So that's probably what they're talking about, is that they had these cases. That's what I'm thinking, is that they've now sort of saved government because they've removed those cases from their books, because it's been inactive. But we are trying to also make proposals in the report on how to deal with such matters. Where am I? I am, sorry. More in terms of what I still want to say, because I know I'm over time. Redress for medical negligence, you specifically asked about that. We are looking, it's covered here, I can't talk about the detail, but it's basically about an administrative redress scheme for medical negligence claims so that you keep it out of the courts, and rather go an admin route. But there's the road accident fund, also the admin route, but because the admin route has failed spectacularly, everything is now back in court. So again, if we have this, we must manage it properly and we must implement this, otherwise it's not going to be of use. We must still prove negligence it would still be a requirement. We did look at no-fault systems, which New Zealand and Sweden, for example, are examples. We can't afford a no-fault system, because then anybody that goes into a public hospital and comes out with a cerebral palsy child would have a claim. As long as they can prove causality, is that what happened there caused what happened to the child, they don't have to prove negligence. That's the difference between no fault and still having to prove negligence. So government will then become liable, and that's one of the proposals for the road accident fund, but then they drastically reduce the money that can be paid out. So even if you were injured and you are now quadriplegic, I think the limit that you will get is something like 15,000, something along those lines, as opposed to 15 million that you could possibly get, because for the rest of your life you're now incapacitated. So it's a judgment that one must make. If you want to reduce claims so much that you pay everybody, but then you pay everybody very little. So we are actually saying we want negligence, we're recommending that it should remain a requirement, which we said in the discussion paper too, so at least I can say it now. But you will still require suitably qualified and experienced people to consider the claims. You need proper staff, you need appropriate administrative support, otherwise it's just another piece of paper. Very important, and I'm so glad we have William here, because he did, I must actually read you the name. He did his doctorate on reconciling patient safety and liability, lessons from a just culture. So he knows everything there is to know about patient safety, and I used his LLD thesis in my report and in my issue paper as well. So the principle of patient safety is that you focus on the patients and you move away from a culture of blame where you try to point fingers at particular people. Because very often your problems is systemic. It's not one single, sometimes yes, it sometimes is one single person that did something wrong, but very often it's an accumulation of cases. And if you look at the aviation industry, where they've managed to bring down fatal airplane accidents dramatically by looking at what was the reason why, and it's mostly several issues that contributed, and then there was maybe one fatal problem that broke the camel's back that then caused the plane to crash. So that is one of the important aspects of patient safety, and the World Health Organization has specifically underwritten looking at patient safety as a component. You talked about the certificate of merit. The merit was a bit misleading, so we rather using the name certificate of confirmation. And the suggestion is that if you institute a claim, you must have a certificate of confirmation. And what you want to do with this is to do away with fraudulent and opportunistic claims and avoid duplication. And it will have to do things like confirm a person's identity, the date of the incident, the public health establishment where it happened. There must be a confirmation of the person's injury or condition by a medical practitioner, and then you would require supporting documents. And that will exclude things like people claiming for cerebral palsy for a child suffering from Down syndrome, people claiming from the state for negligence for children born at home, or people instituting the same claim in different state attorneys' offices and sometimes even in different provinces for the same child, which was mentioned by the Solicitor General, so I have it on good authority. You mentioned ADR and mediation. It is now a policy in government. The state attorney actually developed a document on mediation to move to mediation, to attempt mediation. There's new laws and legislation makes provision for mediation and ADR, and the South African Law Reform Commission is actually now busy with an active investigation into mediation and ADR. And obviously then there's initiatives like the Gauteng High Court instruction that mediation must attempt it. We do already have Rule 41 capital A of the Uniform Rules of Court, but it provides for voluntary mediation, so it's very easy for attorneys to get out of it. There were some cases where the judges actually awarded an adverse cost order against legal practitioners where the judge said, but this was an excellent matter for mediation. You didn't pursue it, you have no good reasons why you didn't, so now I'm penalizing you as the lawyer for not having pursued this avenue. And you wanted also to know about the State Liability Amendment Bill, and that's the last slide. The State Liability Amendment Bill, 16 of 2018, will not be further pursued. Closed chapter. They last considered it in Parliament. It was the Portfolio Committee on Justice and Correctional Services on 26 January 2021. They decided to refer it back to the Minister and not process it further. And they then said that legislation pertaining to medico-legal claims should not be introduced in a piecemeal fashion while the Law Reform Commission is still researching a more holistic approach to medico-legal claims. So everything that was in the State Liability Amendment Bill has been incorporated into the legislation being proposed by the report, and obviously much more detailed and comprehensive because there were flaws in the State Liability Amendment Bill. One of them being that there was no real identification of who's going to be responsible for implementing these provisions. And that's my last slide. I made quick notes here. Do you want me? I don't want to take up, but you said about experts. What kind of experts? Okay. Okay, what's important when you defend a claim, you need a process. Like I said, you must have step-by-step. This is what you do when you receive a claim, so that everybody is clear and each new state attorney and legal advisory person in the province doesn't have to fall around because they don't know what to do. So there must be a process. You must have, say, what documents, what must you do, by what dates, what are your deadlines, because you have to comply with your deadlines. Not doing so can mean an adverse cost order. You must have a realistic evaluation of what is defendable and what is not. And that's why it's important to have medical people, because legal people cannot make that judgment call. Very important, we lose a lot of cases as government. Appoint the best possible legal team. And then appoint juniors, appoint a good SC, but appoint juniors that can learn from that SC, because that SC is not going to practice forever, and you need people. This is a highly specialized field of the law, area of the law. I've had commentators of people that actually appeared as defense witnesses for the state, where that person, the one is a doctor that also has a legal qualification, he said it's embarrassing sometimes to see the mistakes that the state's legal teams make, because it's inexperienced people, they don't have experience of this particular kinds of matters. So he says it's, you know, and then sometimes the judges have to correct the mistakes, you know, point out mistakes that the state's defense teams makes. And believe me, the plaintiffs get the best legal presentation that they can possibly afford. They get people that really specialize in this. I know that there are rules about what people should be appointed. One of those rules is some of the best experts actually work for government. They're the people that are professors in areas of the law that works in a hospital like Steve Biko that's linked to a university. Those people have doctorates in areas of the law, and they train other doctors. And because there's a rule in financial rules is that government cannot do business with their own employees. They're excluded very often from being able to give evidence in cases because they have OWAPs, so they can get paid by plaintiffs to give them medico-legal reports, but government can't use them because we're not allowed to pay them because they already earn a salary. So I've mentioned this to Treasury. I don't have the answer for that. I think it might be possible for a deviation because I feel there's a difference between a person supplying computers who's working for government and a super expert, of which there's one or two in the country, you know, to use that person to help you defend a case. And we're also saying, you know, trying to use joint experts so that you have one expert that both teams use and you don't have this differing versions. Costs is a huge concern. There was you get illegal conduct, such as Nonkuba, which we're all aware of. What he did was eventually just illegal. He started off giving people at least a little bit of money. Then he opened accounts without putting any money into the accounts, and then he ended up just stealing all the money. But you also get attorneys that act legally but unethically. They will pursue a case to the very end, and that's where instances come from, where you run up 19 million costs account with an award of 18 million to the child. It's legal. They didn't do anything illegal, but to my mind, it's unethical to not say, okay, why do you call 30 expert witnesses? Do you really need that many? Can't you agree with the state what both agree on, and you only have one expert to testify on that? You don't get 3 different experts, that sort of thing. And unfortunately, there are opportunistic people that take advantages of weakness in the system. So it's become an industry to an extent where you get people that fund the litigation and they're not subject to the lawyer's 25% or double their fee, which doesn't include the costs. For example, your counsel is paid not out of that 25%, it's an additional cost, and they very often very expensive. So, and then after the compensation orders are given, those people call in their loans, and then there's nothing left because all of that is taken from the compensation award. The dormant matters I've referred to. The Noyele judgment is currently on appeal before the Supreme Court of Appeal, but I know the lawyers often say, how can you send that child back to the same institution that harmed him? Remember, it was maybe the maternity ward that harmed the child because the sisters there didn't do. But the child is not going to be treated by the maternity ward. You know, it will be other people treating them. But in the rural areas, we only have the state hospitals. In the metros, we have lots of wonderful private services. We don't have it. It's not there. In the rural areas, you only have government hospitals. The few doctors that are there are maybe GPs, not experts that know how to treat and rehabilitate a CP child. So we have to find a way of balancing that, you know, to give children services, but don't come up with unrealistic expectations and don't spend so much on the cost to try and prove your point that the child ends up, or the plaintiff ends up getting nothing. Okay. Okay, you said experts. The first thing that we need is an expert in records management because we lose a lot of cases because of poor records. In your medico-legal unit, I said you need legal and medical people. Your experts will depend on the nature of the claim. If it's a CP child, you will need a pediatrician that specializes in neurology. You will need occupational therapists, you will need physiotherapists, depending on the child's disability, you might need speech therapists, you might need audiologists. So the experts will very much depend on the nature of the claim. But when you're trying to get claims done without necessarily going to court, you will need negotiation skills, because you can negotiate with the other team about what we can agree on and what we can. So what's in dispute and what don't we have, because it cuts down on court time and effort. And the best is always to settle as soon as you can. So negotiation skills is very important. If you want to go mediation, you must be aware of what mediation can do. Within government, there should be awareness, but they can't mediate their own matters. You will have to go external for mediation. And mediation is also expensive. Don't make the mistake to think that it's not going to cost you money. It is expensive. Our big flaw in government is that the person sitting at the mediation table is not necessarily the person that has the authority to take financial decisions. You can't send your head of office to all the negotiations, all the mediations, that's obvious. But then at least somebody that has the authority to take a decision must be at least a phone call away. Otherwise, mediation is not going to serve a purpose, because you're supposed to come with an offer during the mediation proceedings. It's no use if you say, I'm so sorry, I must now first do a memorandum, which must go through 50 people before somebody takes a decision. It's going to take 3 months. Then your mediation will fail immediately. Okay, I think that's basically, yeah. You must have your standard operating procedures that people must follow in the hospitals, because that's the easiest way to prove negligence. If there's a standard operating procedure and it wasn't followed, people must know what they're supposed to do, and if they deviate, monitor them, hold them accountable. Otherwise, we will never cut down on negligence and malpractice. Thank you.
Sure. Thank you very much, Meronel van Zyl. I think you've actually brought us a lot of information that is very empowering. And I'm sure Member Hicklin will also request that you also are invited to her committee of health. I think it was important. Maybe just to go through a few before I give over to members to also come in. You said something which is concerning, but I know it's happening. You know, that you have a lot of health professionals who are actually even scared to provide the services because of, the criminal liability that has to do with the environment and, the insurance and indemnity that they need to sign. And I must say, it is true, because there are even people who are scared to serve in these boards that are in health professional boards. And I think it's going to come to where politicians are even scared, to lead such departments, especially Department of Health. It's because, but remember the life Esidimeni that happened. And if these things happen as a politician, you also become liable. Whereas you've got a lot of staff that's supposed to implement, but you must be held accountable as the person who's leading the department. Maybe just for the HPCSA, I know there's, you mentioned something about neurology, I know that there are people who would want to do masters in neuropsychology, but South African universities don't even offer that. And it seems like it's not something that, although you will need them in hospital, and when they study abroad, they come back, it's not recognized in South Africa. Maybe something that you need to look into, so that then we are able to assist the government. Yes, and it's true. A lot of professionals, so medical doctors, or whether it's experts in hospitals, especially at Bara Hospital or the Steve Bikos that we're talking about, a lot of them come from those that, that are associated with universities. And you do know that once you go there, you know that you are under the best care because you've got experts. I gave birth to my daughter at National Hospital in Bloemfontein. I had to pay. It's a public hospital, but because my daughter was an expert, I went to where I knew that I will access it. I was not saying I've got a medical aid, I'll go to a private hospital. So I'm saying there are those hospitals. And maybe something that we need to look into, and the members in the future on, the procurement, the projects that are abandoned, because in terms of administrative law, the Procurement Act is not being implemented, and therefore they're not paying suppliers because there's this protected law cases, whereas they can continue with that. And I really appreciate the information you gave us on the experts. In fact, it was on that slide where you were saying, you must establish a provincial medical legal unit. But at least you now elaborated on which experts are needed. Because I think, as a committee, we also felt that maybe there are these because there are no people screening them, and they delay in terms of that. I'll give and hand over to you, members, if there's anything that you want to. Yes, Member Hicklin, give input on. Thanks.
Thank you so much, Chair, through you. Thank you, Ronelle. I can't thank the three of you enough for these presentations, and I really am going to impress upon the Health Portfolio Committee that we have these presentations made to our entire portfolio, because we grapple as a portfolio committee with the issue of medico-legal claims and how to address them as a health portfolio. But I just want to reiterate, Ronelle, exactly what you said. The biggest problem that we have is one word: implementation. It really just boils down to that. To have a 600-page document sitting on the shelf in your office means zippity-doo-dah-day, nothing. I mean, it's dololo, it's a waste of time. It's great for the printers, it's really bad for the trees. But unless it's implemented, and as you say, the paragraphs, those two paragraphs, are repeated in the Auditor General's report year after year after year after year. And it just goes to my point that if you have accruals of medico-legal claims that are so astronomically high that it will wipe out your entire operating budget for the following year, how are you expected to run a department? And this idea of having a medico-legal unit, either within the health department itself or within the GPG, so that we can actually, as a government, look at the medico-legal claims. For me, it must reside within the health department. But in order for it to be impartial, maybe have it as a GPG or GPT unit, a treasury and a health unit, where you can actually look at the claim and say, I need this expert and that expert and this expert to assess whether this is a claim or not. Because it's like me phoning my medical aid and saying, I need X, Y, and Z medicine as prescribed by my doctor. And the person on the end of the phone, being a clerk who has as much medical knowledge as my chihuahua, it's not going to help. You actually have to have someone who really understands what that diagnosis is, or what the claim is, to ascertain whether negligence could have occurred prior to you actually going through the whole process. And that's when mediation actually can come into play, or whether you can actually say, no, this is clear negligence. And the process to follow for the establishment of that unit really and truly needs to happen. And we need such guidance to actually circumvent the problems that we have, to try and give us an operational budget in health, as opposed to wiping out the operational budget with accruals before we even start. Again, I can't thank you enough for the invaluable contributions each one of you has made to today. Thank you so much. Thank you, Chair.
Thank you, Member Hickling. Member Club, is there? Oh, you are good. No, thank you so much, colleagues, honorable members, and thank you very much for your presentation. We do have a member, a representative from the HSA, but it's now lunchtime, so yes, we're going to request that we adjourn. We'll come back at 2 o'clock to resume with the meeting. And then we'll receive the last presentation from the AG. Thank you.
That's doing presentation on things that you're not allowed to say. There's so many things I consulted if we can just get this report out. So please, everybody, please. Because I'm at wit's end. I can ask everybody at the meeting. Prime Minister. No, it's not she, it's her staff. She said, I'm happy with it.
We are now going to request the AG to table the presentation. The presentation is on the root causes of medical legal claims in the province, the extent of the medical legal claims faced by Provincial Department of Health, the monetary value of medical legal claims in the province, and the medical legal claims on the fiscus, which is the impact of it, particularly in relation to provincial health budgets and long-term service delivery, and what mitigation measures have been recommended or implemented, and the extent to which departments have responded to your audit findings and recommendations. So we'll hand over to you. You'll also introduce yourself and welcome. Thank you.
Good afternoon, Chair and committee members and other colleagues. I'm Mariette Jefer. I'm the Senior Manager responsible for the Gauteng Health Audit, and I'll be doing the presentation today. Are you going to present or to project? Okay, thank you very much.
Okay, let's share the presentation. Can we check if we've received? Thank you. Thank you so much. You may start.
Thank you, Chair. I'll start off with the mission and vision of the AGSA, and I would like to just highlight that in terms of our mandate as a Supreme Audit Institution of South Africa, we are there also to provide an enhanced public sector accountability through the work that we do. The medical legal claims remain a significant fiscal risk for the Gauteng Department of Health. Despite recent interventions, systemic weaknesses in clinical governance, referral systems, and human resources continue to drive high-value claims. These claims have diverted critical resources from healthcare delivery and exposed systemic weaknesses in maternal and neonatal care. While recent interventions have reduced the overall liability, the financial exposure remains substantial and unsustainable without decisive action. This presentation focuses on the medical legal cases presenting root causes, financial impact and mitigation measures implemented in response to the AGSA recommendations and the dormancy process in line with legislation and guidance. If we look at over the past 5 years, the department's contingent liabilities went from 21.8 billion in 2021 to 6.6 billion in the current year, or the past audit cycle ending 24-25. The reduction in the claims is mainly due to data cleansing rather than improved clinical outcomes. During the period, liabilities incurred amounting to 7.3 billion, the additions over the 5 years. There was a total amount of 2.4 billion settled, whereas the budget allocation for the 2.4 billion was only 1.1 billion. So as a result, your goods and services budgets are reduced to settle these amounts. Previously, there was no budget provided for these settlements. In terms of I just want to mention, so in terms of the SIU investigation that's currently ongoing, there is a number of claims, irregularities that was identified, in inflated settlements, and also weaknesses in internal controls. Amongst others, there were duplicate claims. There were claims for people who had passed away, and based on the process, the department has also adjusted those claims on the register. The persistent overspending and governance risk highlights the urgent need for structural reforms and stronger oversight. It is still a very, very large number, and on a daily basis, new claims are added. If we look at the root causes for the medical legal claims, I know the member previously mentioned the cerebral palsy, but if you look at the registers of the department on the contingencies, we can see that the main cause is the cerebral palsy, which is often linked to systemic and operational failures within the health system. So the key root causes is your human resource shortages. There's a chronic shortage of obstetricians, anaesthetists, pediatricians and midwives in high-risk maternity units, overworked staff leading to fatigue and increased likelihood of clinical errors. There's limited training and supervision for junior doctors and community services personnel. There's also an overflow of patients, overcrowded facilities, especially the tertiary hospitals. The hospitals are unable to manage patient volumes effectively, and there's limited access to emergency obstetric care and inadequate neonatal intensive care beds. There's also infrastructure constraints that delay timely interventions during labor. If we look at the ineffective referral systems, there is poor coordination between clinics and hospital, resulting in delays for high-risk pregnancies. There's also a lack of standardized referral protocols and inconsistent decision-making. Also, ambulances are contributing this, and the long travel times between facilities. There's also delayed access to care. This is also a key area that the department has highlighted: patients presenting late due to socioeconomic barriers, lack of health education, and geographic isolation. There's also inadequate triage systems at primary healthcare level, failing to identify and escalate high-risk cases. So these are the root causes that we have identified. If we look at the mitigation measures to address these challenges, the Gauteng Health Department has taken some action, but they need to adopt a multi-pronged strategy to reduce the medico-legal risks and strengthen governance, because we do have the preventative side and we have the corrective side. On the records management, I think a big issue is the records management and the maintaining of patient records, because this sometimes hampers them in cases of legal cases. They can't defend these cases. So in terms of the standardized documentation protocols, enforcing consistent and complete clinical record keeping across facilities, the digital health records rollout is not yet fully implemented, the clinical modules, to be able to access patient records in cases where cases can go to court. Apologies, my cursor is stuck. Okay. In terms of the capacity building and clinical governance, the department also needs to enhance frontline service delivery and clinical risk management, capacitate staff to recruit high-risk areas such as obstetrics, anesthesia, and pediatrics. We have raised a material irregularity on the structure of the department that has not been revised since 2006 to account for change in the demands and to deliver on the strategic plan. Training and development, there is some initiatives where training is taking place at facility level to sensitize staff on documentation standards and medical legal awareness. Also, the strengthening of the oversight at facility level to ensure adherence to protocols and early identification of risks. You will see when I go to the call to action in terms of further deficiencies that need to be monitored. The department is also embarked on an alternative dispute resolution. They are trying to do a proactive approach where they are mediating with claimants to facilitate structured negotiations to resolve claims outside of court. They're also opting for future healthcare coverage, offering continued treatment in public hospitals as an alternative to lump sum payouts, preserving departmental resources while ensuring patient care, and also the strengthening of the legal unit, expanding the internal capacity to monitor cases. That is currently a weakness in the department. Also to improve tracking and ensure timely interventions, and then also the memorandum of understanding with the Office of the State Attorney. It is at this point not possible to get a legal confirmation from the Office of the State Attorney. The department needs to go and access files there as part of our audit process in order to secure evidence. So that is something that really needs to be enhanced. And then also the accountability mechanisms. We are looking at embedding governance and integrity into the medical legal processes. The SIU investigation that is currently still ongoing. And then also internal audits and compliance reviews as part of internal assurance providers. There should be continuous regular assessments performed to ensure adherence to protocols and identify gaps. And then also very important, the executive oversight committees, establishing high-level governance bodies to review medical legal risks and strategic responses. And then also monitoring and oversight that is really required, especially on an institutional level from head office by HOD and delegated officials. Real-time tracking dashboards and the quarterly review forums, those are all gaps that currently exist that needs to be coordinated in a consistent manner. It might exist at some hospitals, but it needs to be coordinated on an overall level. And then if we look at the call to action, so the committee has a critical role in enforcing accountability and ensuring systemic reform. So in terms of what can be done, demand quarterly accountability reports, require detailed responses on medical legal claims, including new cases, settlements, and progress on mitigation measures. These reports should include root causes analysis as well as corrective action taken. The enforcement of audit recommendations and implementation of audit action plans, that is not currently very effective, and we see a lot of repeat findings from year to year. Non-compliance should trigger financial consequences or escalation to oversight bodies, and then push for transparency in settlements, require disclosure of all settlement agreements, including rationale for amounts paid, and verify that mediation and alternative dispute resolutions are being prioritized. And then introduction of performance hearings, a call to departmental leadership to appear before the committee to explain delays, overspending, and progress on risk mitigation, and then also to ensure proper investigation of incidents for consequence management. Mandate that every adverse clinical event linked to a medical legal claim undergo a formal investigation, require documented findings, root cause analysis, and evidence of disciplinary and corrective action against negligent staff or systemic failures. And then without strong oversight and consequence management, these liabilities will continue to drain resources from healthcare delivery. The committee's intervention can enforce accountability, protect the provincial fiscus, and restore public confidence. Thank you, Chair.
Thank you very much, Member Reid, for the presentation. Members, let's deliberate on the presentation. Member Hicklin.
Thank you, Chair, through you. If I could go back to the medico-legal claims analysis, the 5-year analysis slide, if you could just go through it again. I missed some of the comments that you made, but I want to thank you for the presentation that you made, because it once again sets out very clearly what the problems are that the Gauteng Health Department faces, and it all goes down to demanding quarterly accountability reports. And until we actually have that in action, and until we actually have consequence management, when we A, don't get those quarterly reports, and B, don't get adequate explanations, whether it be from the head of the department or whether it be from the MEC, we, as a health department, are never going to be able to account for the overspending and the accruals that the health department incurs. And I have said it in many a finance meeting, we often get told, if only it wasn't for the health department, the GPT would be performing like a star. Well, if only I had one leg, I wouldn't be limping. You can't say that. We do have a defective health department, and that is the biggest problem that the GPT has in terms of audit findings. And it is the biggest problem child in the analysis that we as a finance committee have to do. But could I just ask you to go back to that medico-legal 5-year analysis, because I didn't get the numbers that you were pulling up in terms of medico-legal claims. Please, I'm sorry, I didn't write as fast as you spoke.
No problem.
Thank you, Chair.
To you,
Okay,
Chair.
now I'll give you a chance. Let's just maybe Member Klama, you're sorted. Okay, I wanted to comment. Yes, it's also a pity that we only received it now. There's a presentation we received from is it Ronel? Oh, okay. Yes. Maybe because at that point I did not ask for clarity. But it says none, on your report, it says non-compliance means that most auditees have not institutionalized controls to ensure compliance with legislation. Now, I'm not sure whether you're referring to maybe the internal audit function and the audit committee function. What I would want to get, and I'm going to implore maybe on us as the portfolio committee, when we meet with the departments, we need to also see if the provincial treasury can bring in the internal audit function, because we must be able to understand what is the value of internal audit if all these outcomes are like this each and every year and there's regression. So that we understand what role are they playing, so that there is no recurrence, because what we look at as the committee, we're looking at the impact, on as much as there's compliance that needs to be adhered to, but it must also be aligned to, performance and in terms of service delivery, and the impact as a department. So maybe that we must also come in towards the end, because I'm thinking now with all this presentation that we must be able to understand how internal audit or the audit committee is able to assist us when it comes to, whether it's all UIFW and these claims that we're talking about. What will be their value? Because they are there, but yet things are not changing. One of their presentation is also aligned to what Ronald was talking about, but I think it does show us that gap. It talks about legal and financial risk management, where they're saying they will strengthen the legal unit. Now, it's just a legal unit. It's not a medical legal unit. And I wish you were here when she was doing the presentation, but maybe we can also share that with the AG as well, the presentation that she gave us, because it's very important, because it seems like they're saying they want to collaborate with the state attorney, to reduce these liabilities and improve case handling. There is that point where they are not looking into maybe analyzing the claims first, whether some are defensible or not. So everything they will be taken to the state attorney. In the mediation part, they're saying it, but I think, they need to strengthen there. So, that's my input. You can just maybe respond. Thank you.
Thank you, Chair. I will just go and explain on slide number 4. So on the left-hand side, I've got the 5 financial years, the past financial years, at the bottom 2021, right up to the top for 24-25. So on 2021, the department was sitting with contingent liabilities, claims against the state of 21.8 billion. Okay, so this balance consists of opening balance, and then they will add any new summonses they receive, any cases that were maybe removed due to it being invalid or it was settled, and then they have the element which I'll get back into now in terms of the actual payment of it. So the case might come in for 20 million, but then they might settle for 1 million. So they will take out the 20 million from the balance, but the settlement will be less. So in 2021, they were still sitting on 21.3 billion. Then on 2023, they appointed a service provider to assist them with the sanitizing of the contingent liability register, and they managed to get it down to 17 billion, which then the exercise continued in 23-24 as well, and 24-25. So as we sit now, end of March 2025, the department had legal liabilities in their financial statements amounting to 6.6 billion. And I've indicated before, they did the archiving, the Rules 37B, where they were archiving dormant cases. And I think they reduced it by a further 7 billion, and that's why we're sitting now with 6 billion. On the right-hand side, I've illustrated the amount in yellow is the actual amount in legal claims that were settled in the year. So if we go to 2021, they settled 392 million, and they budgeted 236. And if we go through, you'll see in 23-24, there was a budget of 179 million, and they settled close to just under 700 million. In the year that passed now, the budget was 119 million, and they paid out 428 million. So the amounts that I added up here, so on the left, in terms of liabilities incurred through the 5 years, they added 7.3 billion. And on the right-hand side, the total amount settled by the department over the 5 years was 2.4 billion, for which they had a budget of 1.1 billion. So it means they have reduced the goods and services budget. So where you need critical supplies for your patients, medical supplies, now you're reducing that because you're settling medical legal claims. Okay. Chair, in terms of the compliance with legislation, the role of internal audit is there to go in and test the controls within the department. And they've done that over the past few years, and we see the same trend that we see with our action plans, that these action plans are not implemented. We see a lot of repeat findings from year to year. In the current year, under review, we literally had non-compliance in all the scoped in subject matters for health. So we can see that there is a challenge there with ensuring that officials within the department is complying with laws and regulations, and there is no consequence management for non-adherence and poor performance. So whatever happens, we don't see consequence, and I think we can take it to the medical legal claims as well. There's no investigations done, no consequences taken, and I think that there is no appetite then to take corrective action and to change the narrative. So the role of internal audit is critical, but because of the department set up the decentralized operations, they do need their own monitoring mechanism in the department as well, through risk management and internal control, where they can verify and monitor on a monthly basis at facilities, so that when internal audit comes in, at least you can see that some of the actions have been implemented and corrected. But if there's no such a level there, an internal audit comes in and they keep on raising the same issues, there's no purpose actually then for them doing it, because it repeats. The legal and financial risk management. So the department has a legal section, but it's the state attorney that handles all the litigations. So what we are saying is that the unit within the department also need to monitor the cases that are currently active with the state attorney, because if you don't monitor that, you lose control. And that is the recommendation we made to the department, so that they can capacitate that unit so that cases can actively be monitored and tracked. so that you can see better outcomes.
Yeah, it is very, very scary. I want to check if our stakeholders will also want to maybe have a bite. Merona?
Thank you, Chair. Thank you so much for allowing me this. I just want to ask something because I've never been able to clearly establish exactly how this works. I know that some provinces budget for medical legal claims. And I mean, if you talk about budgeting, it's not only paying out the claim, there's also the legal costs, etc., that goes along with it. And there are other provinces that say, but they cannot budget for medical legal claims, and then they point the finger either at National Treasury or at the Auditor General to say, you have to treat it as unauthorized expenditure, you cannot budget for it. And I've never been able, even I've asked National Treasury directly, and they said, you know, there are sort of two views on this, whether you should budget or whether you shouldn't budget, whether you can budget or cannot budget. So I just wanted to, you know, obtain clarity. Is it possible to budget? And, you know, why is there this belief that it should be treated as unauthorized expenditure and that it cannot be budgeted for? Thank you.
No, thank you very much. Let me just check first. Member Hicklin, were you covered?
I wasn't. Thank you so
All
much.
right. Okay. No, thank you. I'll give it. Sir. Ms. Padayaki, are you all right? Are you okay?
Chair, just slightly different, maybe just as maybe good practice. And maybe this, I'm not sure, there's no one from the department really, but in terms of settlements that are done internally, it's usually the accounting officer that will have to approve a settlement. And I'm not sure what mechanism exists in terms of compiling a proper merits assessment, for example, for the accounting officer to approve. Because I'd like to share a practice that I did many years ago. I was employed in one of the bigger provincial departments of health with the whole legal unit under my supervision. And what we did was, when the claims came in, we had a system of collating that information, and we would do this on a yearly basis, where we would review, etc. And I think some of the difficulties may also be where you, and I just heard maybe there's a capacity issue within the legal department, is if you just relinquish that responsibility to the Office of the State Attorney. Because the State Attorney also deals with other departments, and it may not be practically possible for them to be monitoring the cases the way the department itself should be. Firstly. Secondly, in terms of a database where they could look at trends analysis, for example, if there are interventions that need to be put in specific institutions, etc. That database would also give them some kind of purview over, some of the trends analysis they could do. And I know, there was also input made in terms of consequences, etc. There was a matter that we dealt with in one of the big, was the only central hospital, where it involved the neurologist, and he was the only. It wasn't a neurologist, it was actually a neurosurgeon. And he was the only neurosurgeon who had some capabilities. But there was a huge claim against him that had to be settled. And the hospital did not want to do anything because they would lose the only expertise that they had. But at the end, the investigation revealed that there was considerable negligence on his part. So the point that I'm making is, when these claims are settled, there's usually a very comprehensive assessment that's sent through to the head of department. that details everything about that particular claim, including a very brief merits assessment and also an analysis of all the accompanying expert reports. So at the end of the day, the head of department, when he or she approves that claim, is sufficiently knowledgeable or is sufficiently informed in terms of what he or she is approving, and it's not just left to a team of legal people employed by the state attorney, for example, or private attorneys, but that the head of department can then take steps thereafter in terms of any redress mechanisms or in terms of mitigation steps. But what I'm saying is what it involves is a very sort of, and I think Ronelle also made mention of this, in terms of a very structured kind of approach in terms of not only the record keeping at head office, but also in terms of how the monitoring of that particular claim is done. It's a lot of work, but it does work, because when there are interventions that need to be done, I think it's easier for the head of department to identify those weak spots and actually address shortcomings in that particular facility, for example. Thanks, Chair.
Thank you for that information, Mepe Dayaki. We'll actually be meeting with the department tomorrow and other departments on UIFWs, and obviously we'll also be able to interrogate on some of these matters. So the information that we received today, in fact, is going to help us moving forward. Would you like to comment on the last comment? Thanks.
Thank you, Chair. In terms of the budgeting, we had 2 MIs on the late settlement of court orders, interest paid. And during that time, part of the initiatives taken was that Treasury allowed them now to budget for the medico-legal claims. So Gauteng is in fact budgeting, but it is not sufficient. If we look at the comments in terms of the ideal world where the case will go to the HOD and it will assess, I think those basic elements are currently lacking in the department. I think they're more faced with a situation where they are getting a court order and there's an attachment almost, they have to pay now, they're forced to pay. So in terms of that legal unit doing the job, Chair, that you indicated, that evaluate and assess and track the cases, that is not where it should be. And coupled with the fact that the patient files are not always available, it puts them in a very bad position in terms of wanting to defend cases. And that's why they're now going for mediation, because they simply don't have enough ammunition to defend, so they're trying to settle.
Sure. Thank you very much. Wow. No, but thank you for the information. We'll definitely deliberate this information that we received today. It's heartbreaking, and it's a lot. But I think as a committee, we are here to do oversight and to ensure that people are also held accountable. So we will definitely take. So we really want to thank all of you and you, the AG, and the stakeholders that were here today for all the presentation. Let's note the presentations, members. All right, we are almost done, and before I release the stakeholders, I just want us to go through the last items. It's not going to take us long. Item 5 to 10,
Thank you, Chair. Chair, in terms of item 5, provincial bills, we do not have any provincial bills before the committee. However, the committee anticipates receiving a referral on the provincial adjustment appropriation bill, which is scheduled to be tabled in the House on the 2nd of December. In terms of NCOP bills, Chair, We do not have any before us. However, we also expect receiving a referral from the NCOP on the Division of Revenue Amendment Bill. The bill will be tabled in the National Assembly on the 12th of November. Resolutions striking, Chair, we do not have any. There will be an analysis of same tomorrow, Chair. Petitions, we do not have any petitions, neither do we have any correspondence, and the date of the next meeting, Chair, is tomorrow in the same room. Thanks.
At 10 o'clock. Now, thank you very much, members, and thank you, officials, for all the work that you have put in. Let's all travel back home safely. Those that are staying, let's prepare for tomorrow. The meeting is officially adjourned. Thank you.
Thank you so much, Chair. Thank you to the support staff. Thank you for presentations.
Tiamo, are we all going to reception now? Okay.